featuring NTT, New Trust Technology. Presenting your host, Christian Walters.
Welcome, everyone, to this Monday, August 2nd, 2010 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. Disclaimer, next.
Take notice and acknowledgement with agreement that this show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or implored for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
Again, I'd like to welcome you all to this Monday, August 2nd, 2010 edition of Money, Banking, and Trust. Welcome to NTT. We've been going over the Book 90, Corpus Juris Secundum. We left off on page 866 under section 452, beginning with conditions precedent. That's page 866 under section 452, conditions precedent. In general, one who invokes the aid of to establish or enforce a trust must comply with all essential conditions precedent to the granting of the relief sought. In accordance with familiar equitable maxims, where a person invokes the aid of a court of equity to establish and enforce a trust in his favor, relief will be granted only on condition that he do equity, and that he should come into court with clean hands. Statutory conditions precedents to a suit to validate a conveyance have been held not applicable to the suit to impress a trust on a land purchased by defendant at a tax sale. Suit by beneficiary in an alleged mutual, reciprocal, and irrevocable wills of husband and wife to impress trust on assets of the wife's estate when the will executed by her could not be found, need not be withheld until after distribution of all assets of the estate, and on breach of contract evidenced by a joint and mutual will executed by a decedent and his wife, the breach being accomplished by decedent executing codicil bequeathing property to defendant, and by execution of a deed and bill of sale to him, the beneficiaries of the breached contract can maintain a suit to impose a trust on the property without waiting probate of the will and codicil and distribution of the property to defendants thereunder. A divisee of an interest in property under a will admitted to probate may bring suit to have the trust declared in his favor as to the entire property on the theory that he supplied the funds for its purchase without first being required to renounce the devise. Next section, B, accounting. Under the circumstances of a particular case, an accounting may be conditions precedent to proceedings to establish or enforce a trust. An action at law for money had and received cannot be maintained by a city key trust against the trustee for an amount belonging to the city key trust Until there has been a final settlement of accounts and nothing remains to be done on the part of the trustee but to pay over the amount found to be due, unless the trustee has received money on trust and has never entered on the discharge of its duties. A suit in equity for an accounting of the trust estate cannot be maintained by the beneficiaries under a will before a final settlement of the accounts of the executor or distribution by the probate court. Also, where matters of account are set up as a foundation for a trust, an account must be taken before a decree can be rendered. However, where a grantee holding land in trust and required to reconvey to the grantor makes no claim for an accounting and introduces no evidence that he has contributed more than his share of the price, the interest thereon, and the taxes assessed, and the court is not required to state an account before rendering a decree for reconveyance. A ward on obtaining majority must sue to establish a constructive trust on the proceeds of securities pledged by the guardian to secure his own debt to stockbrokers having notice of a breach of trust without an adjudication of the guardian's account. Section C, obtaining or setting aside judgment, order, or decree in other proceedings. Ordinarily, it is not necessary to obtain or to have set aside a judgment, order, or decree in some other proceeding as a conditions precedent. In maintaining a judgment at law, the issuance of an execution and the return thereof nulla bonum are not conditions precedents to a suit in equity to establish or enforce a trust. Also, it is not necessary that a deed be first reformed or set aside. Notwithstanding a purchaser from the trustee took with knowledge of the latter's fraud, it is not necessary for the beneficiary to proceed against a purchaser to recover the property before suing the trustee personally for fraud. Where the purchaser at a judicial sale is alleged to have acquired the property or in fraud or both the court and the alleged owner, the judicial sale need not be set aside by direct attack before the owner seeks to establish that property is held for the benefit under a constructive trust. A federal court in equity may establish and enforce a trust arising through fraud in favor of a defrauded party without the proceeding in state court through which the fraud is done being first set aside. Next section, appointment of new trustee. Where a trustee has died, the court in which the suit to enforce the trust is brought has jurisdiction to appoint a new trustee, and since such appointment is one of the objects of the suit, it is not necessary that a new trustee shall have been appointed in a separate proceeding prior to the bringing of the suit. Next section, demand. Ordinarily, the Sedekee Trust must move the trustee to take proper action and fail to secure such action before proceeding to enforce his rights. Ordinarily, before a Sedekee Trust may sue in equity to enforce his rights under the trust, he must first have moved the trustee to act and fail to secure such action. However, a demand is not necessary as a conditions precedent to the suit against a trustee where a conversion by him is alleged, or a demand would be of no avail, or where an implied trust is established by evidence, and in some cases a want of a demand is held to be of importance only as bearing on the question of costs. Where fraud is established, no demand need be made in order to recover interest. Where the creditor is a beneficiary of a trust, the presentation of a claim against the grantor's estate is not in the conditions precedents to the right to maintain a bill to enforce the trust, where no relief is sought against the estate or any property belonging thereto. Next section, claim against the estate of trustee or as legatee need not be filed before seeking to recover trust property bequeathed as part of the trustee's estate. Next section, reimbursement of defendant. Generally, reimbursement of a defendant for his advances in connection with the trust property must be made before the trust will be established and enforced. Generally speaking, a trust will be established and enforced by conveyance of property or otherwise as against the alleged trustee or purchaser from him only on condition that the person seeking the relief pay, tender, offer to pay, or give security or indemnity for the purchase price or other advances made by defendant in connection with the trust property. In some cases, however, the rule is not applied, as where there has been fraud or undue influence on the part of the defendant. The amounts in questions were paid out by defendant in another separate and distinct transaction. Nothing has been paid out by defendant in connection with the trust or under an agreement of the parties fixing the time for payment by plaintiff. Nothing is due at the time. Also, a former tender is not necessary where it would be declined, and where defendant has sold the property thereby putting beyond his power to convey the legal title to plaintiff. It would be an idle act for plaintiff to tender the amount expected by defendant by obtaining such title. Plaintiff's payment of the proper amount into court when the suit is commenced is sufficient performance of his obligation. A tender before the suit is not necessary. Next section, reimbursement for services rendered by the trustee or alleged trustee is sometimes held to be conditions precedent to a degree compelling him to transfer certain property to plaintiff. Next section, 453, defenses. Various matters have been considered by the courts and have held to be, or not to be, proper matters of defense in proceedings to establish or enforce a trust. In a suit to establish or enforce a trust, the defendant may set up defenses growing out of the duties as trustee, but there are many matters which are not available to him as defenses, and as matters in no way connected to the trust or transactions pleaded, or which are available only to third persons who are not before the court or are not complaining. While equity will not enforce a trust as to require a violation of law or a trust created for illegal or fraudulent purposes, nevertheless, after the defendant has assumed the execution of the trust, he cannot set up fraud in its execution, and an attempt to purpose or defraud a third person is not a defense, where the agreement or transaction which plaintiff seeks to enforce is not based on dependent on a fraud. When sued for an accounting and conveyance, a trustee cannot set up an adverse title to the property in himself or in a third person through his fraud, but where the grantor of a trust seeks, after the trust is ended, to have the title to the property adjudicated to him, the action being one to determine title, defendant, a grantee of trustee, is not a claim of title under the trust deed, but may set up any other title from any other source which he has to the property. In a suit to impress a constructive trust on the estate owned by a defendant and her husband as tenants by an entity at the time the defendant killed her husband, self-defense may be set up as a defense to the suit. Trustees having set up a corporation to take over a trust may not claim that it could not sue them for the failure of delivery of parts of the assets of the trust. A trustee may not escape liability by showing that the trust property has been dissipated or by merely informing the City Key Trust that he has commenced a breach of a trust. Next section, statutes of frauds. The statutes of frauds constitute a good defense to a bill to enforce a trust, and in any case coming within its terms, except that the trustee cannot interpose the statute to enable him to carry out a fraud on the City Key Trust, and the statute is no shield to a person who fraudulently obtained the trust property from the trustee. Next section, estoppel to put up particular defenses. A trustee or third person may, by his acts or conduct, stop himself to set up particular defenses to a suit to enforce a trust, which otherwise would have a right to interpose. Next section, 454, jurisdiction. In general, the particular court which has jurisdiction of the establishment and enforcement of a trust is ordinarily regulated by local practice or constitutional or statutory provisions. The particular court which has jurisdiction of the questions related to the establishment and enforcement of a trust is ordinarily regulated by the local practice or constitutional or statutory provisions, where the court of law, generally speaking, has no power to declare a trust or to deal with an unexecuted trust. In a proper case, an action for damages for breach of trust may be brought in the court of law. Courts which are given ordinary jurisdiction of all cases at law and in equity have, of course, jurisdiction on the enforcement of trust. And if the jurisdiction is given by the provision of the state constitution, it may not be taken away by the act of legislature. In an action or proceeding brought to enforce a trustee's obligation in which there is no attempt to operate directly on the corpus of the trust, it has been held that the power of the court to act is based on jurisdiction over the trustee and not on location of the trust res. On the other hand, it has been held that the courts of the state do not lose jurisdiction of a trust created by one of its citizens and funds of which have arisen out of property situated in such state because the trustee has removed to another state. A court which acquires jurisdiction of the parties has jurisdiction to enforce a trust, although in doing so, it incidentally affects the title to property. The subject matter of the trust, which is situated in another state or jurisdiction, or although all the beneficiaries reside in another state, it being considered sufficient to give the court jurisdiction that either the trustee or the subject matter of the trust is within its reach. It is ordinarily held, however, that a court of one state has no jurisdiction to enforce a trust either created by a court of another state or where the trustee is acting solely under appointment or jurisdiction of the latter court, but otherwise a court having jurisdiction of the subject matter may enforce a trust as far as such subject matter is concerned, although the trust arose or was created in another state. The parties may not contract to deprive a court of its jurisdiction. Next section, determining right to legal remedy. A court of law is not precluded from considering and passing on the facts constituting the trust to ascertain whether the trustee's treatment of its entitles the beneficiary to a legal remedy. B, equity jurisdiction. Next section. Number 1, in general. A court of equity has jurisdiction of all questions relative to the establishment, enforcement, and protection and preservation of all trusts. The law is well settled that a court of equity has jurisdiction of all questions relative to the establishment, enforcement, and protection and preservation of a trust on real or personal property, especially where the rights to or interests of minors are involved. While it's been said that the trusts which equity enforces are mainly private trusts arising from contracts expressed or implied, all trusts are within equity jurisdiction, whether expressed or implied, and irrespective of whether they are either direct or constructive, created by the parties, or resulting by operation of law. The existence of fraud is not required to confer jurisdiction on an equity court when the circumstances are such as to require its intentions. It has been declared that it is ordinarily on the trust rather than on the trustee as an individual that the court of equity acquires jurisdiction to enforce the trust. Next section, complete and incomplete trust. It has been held that perfect or complete voluntary trusts are enforceable in equity, but incomplete or promissory trusts are not. Next section, jurisdiction of the parties. Generally speaking, jurisdiction of the parties is essential to equity's power to determine controversies with respect to establishment and enforcement of trust, and such jurisdiction is acquired in accordance with general rules. Next section, possession of land by persons seeking to establish a trust thereon for his own benefit is unnecessary to confer jurisdiction on a court of equity. Number 2, nature of jurisdiction. Jurisdiction to establish and enforce a trust is originally and inherent in a court of equity, and according to some authorities, the jurisdiction of equity is held to be exclusive, except insofar as the court of law may, by statute or by rules of court, be given jurisdiction. Jurisdiction to establish and enforce a trust, particularly in cases of strict trust, is ordinary and inherent in a court of equity, and such court may also be vested with statutory jurisdiction. Inherent jurisdiction of equity can be limited or ousted only by valid, expressed legislative enactment. According to some authorities, the jurisdiction of equity is held to be exclusive, except insofar as a court of law may, by statute or by rules of court, be given jurisdiction. This exclusive jurisdiction may be to a class of trust technical and continuous in the nature, which cannot be enforced or effectively administered by any one other tribunal, permitting law and equity to exercise concurrent jurisdiction with respect to some trust. It has been declared that the distinguishing character would seem, in the main, to be adequacy and efficiency of the legal remedy, and in some states, as discussed in section B, number 4 of this section, it has been held that a court of equity has jurisdiction to enforce a trust only where there is not an adequate remedy at law. In cases where equity and the courts of law have concurrent jurisdiction of the subject matter, it has been held that the exercise of equitable jurisdiction rests in judicial discretion. Next, section 3, extent of jurisdiction. Equity's jurisdiction over trust is plenary, and when its jurisdiction is properly invoked, it will afford full relief with respect to the protection and preservation of a trust property and of rights of all parties concerned. The jurisdiction of equity over trust estates is plenary, and when its jurisdiction is properly invoked, it will afford full relief with respect to the protection and preservation of the trust property and of rights of all parties concerned. Thus, where it becomes necessary to complete relief in a particular case, an equity court may not only construe the trust, but will aid in the discovery of the instrument creating the trust, and will also aid the discovery of the trust funds sought to be recovered. A court of equity has jurisdictions when it becomes necessary for the protection and preservation of the trust to appoint or to remove a trustee, as discussed supra section 218 and 234, and to appointment or to control and a receiver. The trustee's breach of trust and his good faith and honesty in dealing with the trust property is within the jurisdiction of the court of equity, and the court of equity has jurisdiction to accord relief for the conversion, misuse, or misappropriation of trust funds or property, to prevent diversion of trust property or other than trust uses, to compel and do execution of trust under which money is held, to settle conflicting claims to the trust fund or property, to require trust funds or property to be turned over to the city key trust or persons entitled thereto, either from the trustee or his representative or from a third person, or may give such other relief as required by the circumstances where the trustee conveys trust property in violation of the trust. Similarly, a court of equity has jurisdiction to repair damage incurred by reason of fraudulent dealing with the trust property, to prevent fraud, and to secure an accounting for a fraudulent breach of trust, as discussed supra section 386. Moreover, a court of equity may compel a discharged trustee from over the trust property to turn over the trust property to his successors. The court may also establish trust and property against persons who hold the legal title and secure conveyances from them to the city key trust, although some of the defendants are in possession of the property, and the bills also prayed for possession. The mere fact, however, that a trust is created on certain properties does not invest a court of equity with jurisdiction to determine all the disputes which may arise from the respect to the title of such property, it being only where the trust or trust estate, as such as the subject matter of the suit, that resort can be had in equity. Moreover, that jurisdiction should be confined to cases of controlling legal rights vested and remaining in trustees created in such some proper mode. It should not be extended to all cases of abused confidence. It has been held that the mere fact that personal property is held on a constructive trust does not give equity jurisdiction toward its transfer in specie to the person in favor of whom such trust exists, but such transfer will be ordered only when, in addition to the existence of the trust, that are present additional facts which justify and require the exercise of the equitable powers of the court in this respect. The court of equity has been held to have no jurisdiction to enforce an executory voluntary trust, or of a suit which is virtually one of determine the legal title to the land, or where no trust exists with respect to the subject of the suit. Moreover, equity should not attempt to deal with a trust which has been fully administered and has ceased to exist, where nothing remains to be done but to physically deliver the trust property of the person entitled to its possession, or where no doubt exists as to the identity of such person, or where no question has been raised as to the trustee's acts or accounts. The court of equity cannot make a new trust agreement for the parties thereto, but the court does, however, have jurisdiction of a bill to determine whether, on the face of the instrument, the trust has been created. The jurisdiction of the court is not necessarily ousted by the fact that the contract relied on to create the trust is oral. Where the issues presented by the complaint are equitable, issues presented by a cross-complaint involving the same subject matter are also within cognizance of the court of equity trying the case. Next section, territorial extent. A suit in equity for the declaration and enforcement of a trust is maintainable in a jurisdiction where defendant is found, even though the trust property may be situated in a foreign jurisdiction, or the granting of relief prayed for involves the interpretation of a will which has been admitted to probate in a foreign state. So a trustee who is in the state may be compelled to convey the legal title to lands held by him in trust and lying without the jurisdiction. A court of equity may exercise jurisdiction over an action for the enforcement of a trust where the trust property is within the jurisdiction, notwithstanding the trust has been created in another jurisdiction where all the parties reside, and where only the fund remaining undisposed of is a judgment of the courts of the state where the suit is brought. It has been held that a court will assume jurisdiction at the instance of the maker of a trust deed to protect the residue of the fund from misapplication and have the trustees to account even though the trust was created in another state. If the trust property is within the territorial jurisdiction of the court, it may be restored to the equitable owner, although the trustee remains outside the jurisdiction of the court. However, a court may properly refuse, on the ground of comity, to take jurisdiction of the case involving a foreign trust, where adequate redress may be obtained on the courts of the state where the trust arose, and an action by the landlord against tenants to establish a trust in lands in another state purchased at a judicial sale will not be entertained where such purchase, if fraudulent at all, was only constructive or legal and not actual fraud. A court of equity may not declare a trust on lands in another state where a party is to be charged as trustee. It is not within the jurisdiction of the court. Where the trust involved is created by judicial decree, it has been held that it is in its terms are enforceable only by the courts of the jurisdiction where it was created. Next section, testamentary trust. If a trust is created by will and in the state where relief is sought, the courts thereof may compel persons within the jurisdiction to execute the trust over lands in another state, even though the will is not probated therein. For in such case, the action is not in rem or one to establish title, but is in personam to enforce a personal obligation. So also Chancery would take cognizance of a suit by creditors and heirs residing without the state against the executor or administrator of a trust who died within the state, so subject his estate to the payment of a fund not accounted for, even though trustee was appointed under a will in a foreign jurisdiction. Also, where services of summons could be had on trustees who reside in England, a state court has been held to have jurisdiction of an action by a resident of another state against such trustees to recover the price of the land in another state purchased by the testator in his lifetime. However, it has been held that a court has not equity jurisdiction to compel the performance of a trust arising under the will, under a will provided in another state where such has not been probated nor copied, filed, and recorded in the state of the form, and the Chancery may not direct an acting executive residing within the state to sell land lying without territory according to the directions of a will executed within the territory. Next section, number 4, adequate remedy at law. The rule which limits the jurisdiction of equity to cases where there is no adequate remedy at law does not, generally speaking, apply to equity court in the establishment and enforcement of trust, and the fact that plaintiff has a plain, adequate, and complete remedy at law will not necessarily deprive equity of jurisdiction, especially where there are other grounds of equity jurisdiction present. But the existence of such remedy may result in the denial of relief in equity. Equity has jurisdiction in cases involving establishment and enforcement of trust where there is no adequate remedy at law, or the remedy at law is not completely adequate. However, the rule which limits the jurisdiction of equity to cases where there is no adequate remedy at law does not, generally speaking, apply to an equity court in the establishment and enforcement of trust, the jurisdiction of equity in such cases being, as a general rule, in addition to and concurrent with any remedies at law the party against the jurisdiction of a court of equity in such cases is not ordinarily taken away by the mere fact that the party seeking to enforce a trust also has some remedy at law, or even a plain, adequate, and complete remedy at law, especially where the person seeking relief is entitled to discovery, where the trustee is bound to state an account of trust fund or its proceeds, and where a case is complicated, or where there is fraud, where the remedy at law creates no new rights in the city trust, or where it is necessary to appoint a new trustee. Nevertheless, the remedy at law is adequate and complete. Such remedy should ordinarily be pursued, and the existence of such remedy may result in denial of relief of inequity, and there exists authority to support this view that a court of equity will entertain jurisdiction only where there is not a plain, adequate, and complete remedy at law. In any event, it is necessary in order to deprive equity of jurisdiction that the remedy at law should be as clear, efficient, complete, and effectual as the remedy in equity. Where the jurisdiction at law and inequity is concurrent, the court of law first obtains jurisdiction without the intervention of some special cause rendering the jurisdiction of law inadequate. A court of equity may not interfere, nor has a court of equity jurisdiction of a question, which is a legal one, exclusively within the jurisdiction of a court of law. Next section, probate or orphans court. probate or Section C. As a general rule, probate, surrogates, or orphans courts have no jurisdiction to establish and enforce a trust in an estate subject to the jurisdiction, except to the extent that such jurisdiction is conferred on them by valid statutory provisions. While a probate, surrogates, or orphans court may order the distribution of trust funds belonging to the estate subject to its jurisdiction and may for that purpose determine who are entitled to receive them, as a general rule, it has no jurisdiction to establish and enforce a trust in the estate, except to the extent that such jurisdiction is conferred on it by statutory provisions. And even where such jurisdiction is given, unless it has been made exclusive, it does not deprive a court of equity of its original jurisdiction in such matters. Statutes giving probate or orphans courts jurisdictions of particular types of trust, such as testamentary trust or express inter vivos trust, do not enlarge the jurisdiction of such courts over other types of trust, nor do such statutes affect equity's jurisdiction of other types of trust. The general jurisdiction of the court of equity and the latter of the enforcing trust is not taken away by a statutory provision giving to a probate jurisdiction of claims against estates where a decedent has received money in trust for any purpose. The provisions conferring on a probate court's jurisdiction in all probate matters have been held not to include additions for the enforcement of trusts involving decedent's estates, although it has been held under similar provisions that the probate courts acquire jurisdiction to establish and enforce trusts involving such estates. Equity is not deprived of jurisdiction by a probate court where it is sought to impress a trust on trust property received, apparently without restriction under a will, and where there are trusts to be executed which the probate court may not enforce or fully administer. Equity will assume jurisdiction of the administration even after it has been commenced with the probate court. Even after it has been commenced with the probate court. Continuing on, where a decedent's estate has been fully administered in a probate court, a suit to impress a trust on property received has been held to be within the jurisdiction of a court of equity. On the other hand, a court of equity has no jurisdiction of questions which are within the exclusive jurisdiction of the probate court, or concerning which it can grant adequate relief. Moreover, where remedies are concurrent and the probate court has acquired jurisdiction first, and the remedy afforded it is not inadequate, a court of equity may not interfere. Next section, 455, venue. Subject to statutory provisions, in a proper case, a suit to establish and enforce a trust may be brought into a court in which the trust res is situated, but generally such suit is regarded as transitory and may be instituted in the county in which the trustee or one of the defendants resides, or in which jurisdiction may be had of the trustee. Statutory provisions are governing the venue of suits to establish and enforce a trust where they exist, control any general rules as the rights of parties seeking the aid of courts to select the forum. In a proper case, a suit to establish and enforce a trust may be brought in a county in which the trust res is situated, but generally such a suit is regarded as transitory and may be instituted in the county in which the trustee or one of the defendants resides, or in which jurisdiction may be had of the trustee, although the property, which is subject to the matter of the trust, lies in another county or jurisdiction. Next section, 456, time to sue, limitations, and latches. In general, a suit to enforce a trust or to recover trust property must not be brought prematurely and must be brought within the time prescribed by applicable statutes of limitations, and apart therefrom may be barred by latches, that is, undue and unexplained delay working an injustice to the defendant. A suit to enforce a trust or to recover trust property must not be brought prematurely, that is, before the cause of action has occurred. After the accrual of that cause of action, such suit must be brought within the period of time prescribed by statutes of limitations specifically applicable. As a general rule, limitations do not start to run until the trust has been repudiated or terminated, and knowledge of a notice thereof is acquired by the party seeking to enforce or establish the trust. Apart from statutory limitations, while it has been held that latches may not be interposed on one holding property as trustee, it is generally held that a suit to establish or enforce a trust or to recover trust property must be barred by laches. The fundamental requisite essential for the application of the doctrine of the laches is undue and unexplained delay working an injustice to the defendant. In determining whether plaintiff is barred by laches, various factors are to be considered, including the length of time elapsed, whether plaintiff knew or had reason to know of facts arising to cause of action, concealment by trustee of facts which he has under duty to disclose, whether plaintiff was under an incapacity, whether plaintiff's beneficiary interests were presently enjoyable or enjoyable only in the future. In a case for a suit of breach of trust, whether plaintiff beneficiary had complained of the breach of trust, the reasons for the delay ensuing, change of position by the trustee including loss of rights against third persons, accrual of intervening rights, unavailability of witnesses or parties as by reason of death, hardship or inequity to plaintiff in relief is not given, and hardship or inequity to defendant if relief is given. In particular cases of facts which be insufficient to sustain a defense of laches, mere delay short of the period fixed as a bar by statutes of limitations will not of itself preclude the assertion of city key trust of his equitable rights. A suit will not be barred by laches where it is brought within the reasonable time after plaintiff acquired or should have acquired knowledge of the facts, or defendant has not been injured or prejudiced by delay, and it has been held that the laches will not begin to operate until the trust has been repudiated. The defendant may waive the defense of laches. In numerous decisions, the courts have so stated that rules with respect to laches as to refer to particular kinds of trust under consideration, as discussed infra sections B through E, whereas text discloses many of these rules, although so worded as to refer only to the type of trust, are identical with or similar to the rules relating to other types of trust. In a particular case, there may be or may not be laches regardless of whether the trust under consideration is classified as express, implied, resulting, or constructive. Next section, B, express trusts. A suit to enforce an express trust must be brought within the time prescribed by applicable statutes of limitations and may be barred by laches, although ordinarily, as long as the relation of the trust and the city key trust continues to exist, no mere lapse of time will bar the city key as against the trustee. A suit to enforce an express trust must be brought within the time prescribed by applicable statutes of limitations, but a statute limiting the time for enforcement of an implied or resulting trust does not prevent the enforcement of an express trust. Limitations do not begin to run until the trust has been repudiated, and then only from the time the beneficiary acquires knowledge of the breach. Apart from statutory limitations, the doctrine of laches may be invoked in the case of an alleged express trust, in some instances successfully. While it has been declared that there is no distinction between express trust and resulting and constructive trust as far as laches in the statute of limitations are concerned, it has been held that laches will be applied less readily in the case of an express trust than in the case of an implied, resulting, or constructive trust, or in a contract not involving any relation of trust or confidence. In the case of a continuing express trust has been strictly such and is recognized and enforced in courts of equity only as long as the relation of trustee and city key trust continue to exist. Ordinarily, no mere lapse of time will bar the city key trust right in the subtrustee. The doctrine of laches applies to the enforcement of express trust when only when there has been an open and unequivocal breach of repudiation of the trust, assertion of an adverse right, title or interest, or other act of hostility to the trust by the trustee, which has been so brought home to the actual or constructive knowledge of the city key trust as to require him to assert his rights promptly, and with knowledge he has inexcusably and unreasonably delayed asserting his rights to the inquiry or prejudice of the defendant, or under the circumstances the lapse of time has been such as to give rise to a presumption of discharge or of the trust, or such to obscure the acts of the parties or the nature of and character of the trust, and where there has been deaths of witnesses or loss of papers, Also, as the bar to the express trust arising from the lapse of time depends on the discouragement of the laches and negligence, rather than on an analogy in the statute of limitations, a trustee is not entitled to the defense of laches, although more than the usual time to raise a bar has elapsed, whereas conduct has been such as to show fraud or bad faith. Moreover, as one in peaceable possession of property, which is the subject of an adverse claim, is not chargeable with laches or for delay in instituting a suit in equity to enforce or protect his rights, as discussed in equity, section 116B, laches cannot be interposed as a defense to a suit to establish or enforce an express trust brought by one of those whose claims to the property has been united with the possession. Nor can the defense of laches be interposed against one who, during the period of delay, was under no duty or obligation to act, and the party may be precluded from charging laches by reason of being in pari deducto. Subject to the foregoing rules, the applicability of a doctrine of laches to a suit for the enforcement of the express trust depends on the circumstances of each particular case. Next section, C, implied trust. A suit in equity to establish or enforce an implied statute and may be barred by laches. A suit in equity to establish or enforce an implied trust may be brought within the period prescribed by statute, and apart from statutory limitations, suit may be barred by laches. In the absence of a statute of limitations governing implied trust, such suit may be brought within the reasonable time, it being barred by unreasonable delay. In a particular case where there may not have been such laches or as to bar relief, as where there has been fraudulent concealment or other cause for delay. Next section, D, resulting trust. A suit to establish and enforce a resulting trust to be brought within the time limits by statute and may be barred by laches. A suit to establish and to enforce a resulting trust must be brought within the time limit by statute. While it has been declared that laches is of little significance in the case of a resulting trust, the person may be precluded by laches from maintaining a suit to establish or enforce a resulting trust in his favor, where under the circumstances of the particular case, he has, with actual or constructive notice of the facts, delayed an inexcusable and unreasonable length of time before asserting his rights, especially where the nominal purchaser has occupied and enjoyed the property, or to the knowledge of the City Key Trust has continuously asserted adverse rights to the property, or rights which the City Key Trust has constantly recognized, or where the evidence of the original transaction is very uncertain and the result of the length of time intervening between the alleged creation of the trust and its attempted enforcement. It has been declared that the institution of the suit to establish a resulting trust after the death of a person so to be charged as trustee is a strong circumstance for refusing to establish a trust. On the other hand, there may be no laches under the circumstances of a particular case, as where a delay in bringing suit is not unreasonable or is satisfactorily excused. There has been no charge in the parties or their status. The delay has not prejudiced the defendant so as to make it inequitable to grant the relief sought. The trust is admitted or has never been denied or repudiated, and the trust has always recognized the City Key Trust rights or has not asserted any adverse claim. The beneficiary has no knowledge, actual assertion of the adverse right, or he has no knowledge or means knowledge of the facts until within reasonable time before seeking equitable relief to enforce the resulting trust, or where during the period of a delay he has been in possession or joint possession with trustee of property or has been exercising acts of control and ownership over the property. Time does not commence to run against the beneficiary of resulting trust so as to render the doctrines of laches applicable until the trustee disavows or repudiates the trust, and such disavowal or repudiation is fully and unequivocally made known to the beneficiary. Next section, E, constructive trust. A suit to establish and enforce a constructive trust must not be brought before the cause of action occurs and may be barred by the statute of limitations or by laches. A suit in equity to establish and enforce a constructive trust must not be brought before the cause of action occurs. On the other hand, to be entitled to maintain such suit, plaintiff must have been diligent in asserting the rights asserting the facts and applying to the courts for redress. The suit may be barred by the statute of limitations or by laches. Neither the statute of limitations nor laches will begin to operate as a voluntary constructive trust until the trustee has repudiated or acted in hostility to the trust and the knowledge of the repudiation is brought home to the beneficiary. Suit may be barred by laches where plaintiff delayed beginning suit an unreasonable length of time after his right of action accrued, and he has notice or opportunity to acquire knowledge thereof, and no sufficient excuse for delay is shown, particularly where, in the meantime, strangers have purchased or acquired rights in the property, and his claims is not refreshened or relieved of the laches by its passing from hand to hand. The institution of a suit to establish a constructive trust after the death of a person so to be charged has been held to be strong circumstances for refusing to establish a trust. On the other hand, a particular suit may not be barred by limitations or laches. A suit is not barred by laches where it is brought within a reasonable time after the cause of action accrued or after plaintiff acquired or should have acquired knowledge of the facts, and the delay is not substantially misled, injured, or prejudiced defendant, or there is sufficient excuse, such as the plaintiff, without negligence on his part, was ignorant of the facts. In determining whether a plaintiff in a suit in equity to force a defendant to the character of the trustee of a constructive trust is guilty of laches, the court will sometimes be, by analogy, apply the same limitation as to provide for actions at law. However, it is not bound to do so. What length of time will bar the constructive trust depends on the circumstances of each case, and the claim may be stale so as to disentitle plaintiff to relief under the circumstances of the case, although less than the statutory period has elapsed, or he may be entitled to relief, although the lapse of time has such made greater than the statutory period. Next section, 457, part necessity of parties. A, as a general rule, all parties who are legally or beneficial interested in the subject matter of the suit and whose interests will be affected by the decree therein are necessary parties to the suit to establish and enforce the trust, but persons who at the time of the institution of the suit have no interest in the subject matter thereof, which are material or will be prejudicially affected by a decree therein, or whose interests are mere expectancies or future contingent interest, are not necessary parties. As a general rule, all parties who are legally or beneficially interested in the subject matter of the suit and whose interests will be affected by the decree therein are necessary parties, either as complainants or defendants, to a suit to establish and enforce a trust. This includes the creator of the trust, except where the property has not reverted to him in any event, and all persons who are entitled or claim to be entitled to the trust estate. On the other hand, persons who are not necessary parties include persons who, at the time of the institution of the suit, have no interest in the subject matter thereof, which are material or will be prejudicially affected by the decree therein, or whose interests are merely expectancies or future contingent interests. Next subsection, City Keys Trust or their heirs, personal representatives, or assigns. All the City Keys Trusts are necessary parties to the suit to establish and enforce a trust, and on the death of the City Key Trust, so are his heirs or personal representatives. The rule is subject, however, to the exception that the City Key Trust need not be parties to the suit in which their interests are fully represented by an executor of the estate or the trustee, who is a party, or perhaps where the trustee is empowered by an instrument creating the trust to dispose of the trust property in an absolute manner without the consent of the beneficiaries, or where such instrument gives the trustees broad powers to collect obligations, or where the beneficiaries are very numerous. It has been held then on a bill by an assignee of a part of an interest of a City Key Trust to enforce the trust. The owners of the other party will not be indispensable parties. The trustee may be sued by the City Key Trust without making the other beneficiaries plaintiffs or defendants where the action is for a personal wrong to the plaintiff or is to recover plaintiff's definite and ascertained share of the trust fund, but all the beneficiaries are necessary parties where the suit is brought to establish their respective equitable interests or relates to an uncertain share of the trust fund. Next section, trustees as or heirs or personal representatives. Generally speaking, in a suit relative to the establishment or enforcement of a trust, the trustee is a party, and if there are two or more trustees, all must be parties. In case of death of a trustee, necessary parties include his personal representatives, or if the trust property consists of real estate, his heirs or devisees. In some instances, however, these rules are not applicable. Next section, assignees or purchasers of trust property. A person to whom title of the trust property has been assigned or conveyed as a necessary party to the trust to enforce the trust against the trust property itself, unless the transfer or the assignment was void on its face, was merely colorable with intent to defraud, or was made after the institution of the suit, but it is not a necessary. But he is not a necessary party to the suit to enforce a personal liability against the trustee and compel him to account for the property transferred or to establish a trust in property other than that transferred to the transferee in question. B, proper parties. Number one, in general, all persons are legally or beneficially interested in the execution of the trust are proper parties to the suit relative to its enforcement. All persons who are legally or beneficially interested in the execution of a trust are proper parties to a suit relative to its enforcement, and this includes the beneficiaries or sedicee trust. But the Attorney General is not a proper party in a suit involving a private trust, and the Secretary of the Interior is not a proper party to the suit to have a trust declared in an oil claim and a prospecting permit issued to the defendant. An allegation in a bill purporting to join an unincorporated trust as a party may be disregarded. Next section, intervention. A person possessing the requisite interest may be allowed to intervene, but it is not error to deny a petition to intervene where it does not appear that the rights or remedies of petitioner can be affected by a judgment between the parties to the suit. Furthermore, the addition of the complainant's husband as a party complainant at the same time to final decree was ordered in his favor without a pleading by him and without an opportunity to defendant to plead is improper. Number two, complainants. As a general rule, the proper person to bring a suit into relative to a trust is the trustee. But in some circumstances, the sedicee trust or his heir or administrator is the proper complainant. A person who has no interest in the subject matter or is not entitled to any relief in the premise is not a proper party complainant in the suit to establish or enforce a trust. As a general rule, the proper complainant to bring a suit against a third person relative to the trust, such as for the recovery of trust property, is the trustee and not the sedicee trust, except where the trustee neglects or refuses to act or cannot sue because of his own fraud or neglect of duty or has acquired adverse interest and is made a party defendant. But as against the trustee or his executor to the proper party complainant to enforce the trust is the sedicee trust, or after his death, accordingly as the property involved is real or personal property, his heir or personal representative. A person who has no interest in the subject matter or is not entitled to any relief from the premise is not a proper party complainant to the suit to establish or enforce a trust as, for example, the executor or administrator of a decedent who created the trust. Next section, joinder or representation. All persons may join in the suit to establish and enforce a trust who have similar interests arising out of the same trust and who are seeking the same relief, although their interests are not joint, and the joinder of the person without interest has been held not to be fatal, but persons whose interests are in conflict with each other may not be joined as complainants. Where the sedicee trusts are numerous, a bill to complain the execution of the trust may be maintained by part of them on behalf of themselves and all others interested without joining such others. And as against the third person, on the trustee's neglect to or refusal to act, some of the beneficiaries may sue without joining the others as parties, where the court can do justice to the parties before it without injury to the others. Number three, defendants. In a suit to enforce a trust, all persons interested or claiming an interest in the trust property or a result of the suit are proper parties to defendant. But a person who has no interest in the trust property or any of the objects of the suit and against whom no relief is prayed is not a proper party defendant. In a suit to enforce a trust, all persons interested or claiming an interest in the trust property or the result of a suit are proper parties defendant. On the other hand, a person who has no interest in the trust property or any of the objects of the suit against whom no relief is prayed is not a proper party defendant, and in an action against a trustee to obtain from him a conveyance of a legal estate, persons in possession of part of the property as tenants at will of the trustee are not proper defendants. It has been both affirmed and denied that the grantor or vendor is a proper party defendant to a suit to establish a resulting trust in real property, where in a suit by a city key trust against a third person, the trustee cannot properly be joined as complainant. He is a proper party defendant. City key trust who refuses to join as complainants in a suit to enforce a trust or who claim present interest opposed to a plaintiff should be made parties defendant therein. Next section, joinder. In a suit to declare and enforce a trust, all parties who are entitled or claim to be entitled to the trust estate or to an interest therein are properly joined as defendants, such as the trustee and subsequent purchasers and encumbrances under him. Where there are several trustees who are all implicated at a common breach of trust for which a city key trust seeks relief in equity, he may bring his suit against all of them or against any of them separately at his election. In the case of the death of any such trustee, their personal representatives may be joined with the survivors as defendants. Likewise, where one or more third persons have aided, abetted, or conspired with the fraudulent trustee in committing such breach of trust, a suit may be brought against all or only some of the wrongdoers, and where the primary and important subject matter of the suit is the preservation and restoration of the trust fund, which has been maladministered, it is not necessary to the application of the rule that all the defendants were jointly concerned in every act of wrong, where there is a series of acts contributing to the plaintiff's injury and produced by the same fraudulent intent. In a few jurisdictions, however, a third person who has taken a conveyance from the trustee with notice of the trust or without consideration must be joined with the trustee in the suit by the city key trust. In an action of assumption for money had and received cannot be maintained against two trustees jointly unless there has been a joint promise expressed or implied. Also, in an action at law to recover statutory damages from a trustee, it is improper to join as defendant a receiver of plaintiff's property appointed in supplementary proceedings where it is not jointly or severally liable on plaintiff's claim and has no connection with the other defendants. Probate guardians of infant defendants should not be joined as defendants. Next section, 458, process. We'll stop there and let's go a little farther. Section 458, process. Pertinent statutory provisions are to be followed in issuing and serving process in the suit or proceeding to establish or enforce a trust, and where no specific method or service is prescribed by statute, compliance with an order of the court relative thereto has been held sufficient. Pertinent statutory provisions are to be found as in issuing and serving process in a suit or proceeding to establish or enforce a trust. In order to effect valid service of process outside the state in a matter relating to an express trust, there must be jurisdiction of the court over the subject matter concerning the application is made. Under some statutes, a suit in equity to enforce a trust may begin by inserting the bill of complaint in a writ of attachment and serving it on defendant. Where a city key trust assigns their income in crucio to courts will not direct the payment of such income to the assignee until all the city key trusts have been cited or jurisdiction over them has been otherwise acquired. Whether no specific method of service is prescribed by statute, compliance with an order of the court that the notice of the hearing been given by posting, by mailing to the beneficiaries, and by serving the trustees and also the guardian of the estate of a minor beneficiary has been held sufficient. Acceptance of service by an attorney on behalf of the named person as one of within the named defendants relates to such persons in the capacity of trustee, that being the only capacity in which he was sued and was not ineffective as referring to him as an individual. Next section, 459, discovery. The right of the parties to a discovery in a proper case has been recognized in connection with actions to establish or enforce a trust. The rights of the parties to do discovery in a proper case has been recognized in connection with actions to establish or enforce a trust and accordingly, as shown in Discovery, Section 71A2, production and inspection of books kept by a trustee will ordinarily be required when sought by a beneficiary of the trust. Where the beneficiary seeks a disclosure of facts from a trustee, it is unnecessary to allege that no one else except the trustee knows the facts. Under some statutes or rules of court, since the bill in equity to establish constructive trust sets up a claim of equitable standing without a discovery, it is not necessary for it to be verified by affidavit in order to entitle complainant to a discovery. Next section, 460, complaint or petition. On page 898, we'll begin at section 460 next time. So we'll start the Q&A.
Q&A session started.
So press star 6, star 1 to raise your hand and get in the queue, ask a question. Press star 6, star 1 to raise your hand and get in line. Floyd, you're on
Chris. Hi, Floyd.
Hi, Floyd.
Yeah. When you're putting in for a, say you're starting an action in trust to be heard in camera, do you write the protective order, or do you get the judge to write the protective order?
You write the order, although you could probably ask him for one, but, you know, you're probably the best one to write the order. Who knows what the judge's going to leave out?
Okay, so when you're writing a protective order, what do you put in there so that now what you're writing for the protective order is going to be shown in camera? That's my understanding. And but now you're putting it in through the public to get it past the bleary-eyed watchers, and so you need to write your what do you call what do you I can't think what you call.
There's two protective order. There's the order itself, and there's the motion for protective order. Now it comes down to exactly which one you're talking about, because the judge can write the order, but you wrote the motion for the protective order.
Okay, but you
I would write both of them.
Excuse me?
I would write both of them. But
okay, so you
definitely have to write the motion for protective order. That's one thing. Then I would offer yourself for the judge to be signed. That way, I'm not leaving anything out that I want protected.
Okay, so when you write the order, you have to put everything in there that you want protected.
Everything is probably in the mentioned in the motion itself has to be included in the order. Now we have examples of that. It's almost like a duplication from one to the other.
Okay, I don't think I've seen one of those.
It's on the site, I believe. It's an example out of Federal Rules of Civil Trials out of O'Connor's. An example, protective order and a blank protective motion. Motion for protective protection.
So that's Federal Rules out of O'Connor's. That's what you said?
O'Connor's, yes. Federal Rules Civil Trials, O'Connor's.
Okay.
Full of
Federal Rules.
I know JC, because I gave a copy. I believe I gave Eric a copy, so Eric and JC do definitely have those two, and I think we put it up on the site. So.
Okay. Is that the one that I have access to or not?
I don't know if you got access into it yet or not. Marshall does. Right,
Okay. Well, okay. I'm going to have to write a protective order. Let's see, order.
Wrote the
All right.
protective order, you know what's in it, and the motion. You got to write the motion. The motion comes first. The motion for protective order comes first.
Okay.
Then there's the order that goes with it. If you write the motion is basically going to be duplicated in the order for what you want.
Okay.
If you wrote the order, if you wrote the motion, the order is no problem.
Oh, okay. Well, basically, what you're doing is you're trying to protect the fact that you're going in. You want to go in camera with what is it? Not classified, but with material that. Yeah. Pardon me.
Confidential information.
Yeah, confidential information. Right. Do you have to and you have to spell out what that confidential information is, I assume?
You have to identify it.
Okay. Well, now, when you identify it, are you saying that it's a like this is a trust, or are you saying this is trust information? Or exactly, how would you form your
hang on ground that we're making new grounds, new strides, and this is going to have to be one of those trial and error things.
Okay.
How much do we put in and close to not give it all away and waive it, and how much not to put in, but yet to identify enough so you can get a protective order.
Okay.
But you've got a trust.
Yes, I do have a trust.
It's confidential.
Right. Okay.
Well,
I came up with some information today that I put in my that I'm going to put in with my cover.
Wait a minute. I just thought of something.
What?
Just like the notices we put on the public side that are the mirrors pointing to the private, that's exactly what we should do here. We should put in enough information to mirror in that motion that the actual private stuff that he has is already in the chambers.
Okay. Let me pull something up real quick here. Okay, this is what I'm working on right now. It's my circuit court case, is what I call it.
Let's start working on hypothetical things and start leaving off the technicalities that will implicate us all.
Yeah, right.
Thinking about, hypothetically, I got a case going on. Say, well, you don't even have to mention a case. Let's just start working in hypotheticals from here on.
All right. Well, this is a hypothetical case that I'm trying to get together in case I ever need it, and I put in things like grantor settler of the express revocable modifiable trust herein filed in. Good faith as, let's see, good faith as follows. In regard to blah, 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 uniform. The previous proceeding was contrary to equity. A debt is extinguished with discharge. A duty is owed. Equity will not suffer a wrong to be without a remedy. A specific performance is denied. There exists no adequate relief at law, and so on and so forth. And I put in a few other poignant points, and I was wondering, would that include? Would that be apropos for a protective order?
What were you mentioning about right?
Well, I'm mentioning about equity, and equity is my right to equity has been denied.
Okay, so that would be more like a no adequate remedy at law.
Yeah, and I put in this: notice is hereby given without waiving any right, remedy, or defense. That I'm competent with intent and purposes, grantor settler of the express revocable modifiable trust herein filed in good faith, and I state as follows, and then I went through what I just said. There's a few more points that I made.
I think you need to go to your local states and go on the internet there and see if you can get the rules of evidence in your state and probably the rules of court. Check out on Discovery what it says about protective orders and confidential information.
Okay,
and
so
then
that's rules?
make reference to your evidence rules, and then read the section on the evidence rule what applies to confidential.
Okay, so that's rules of evidence, and that's what was the rest of it?
The state rules of evidence.
Yeah.
Your local rules of court.
Local rules of court. Okay.
And do a little more research on what is going to qualify as confidential information or what is going to need to be protected.
Okay. All right. All right, I'll have to do that in the next day or so. Okay. Very good.
I don't know if Marshall's done anything on that or not, or maybe Eric might have.
Yeah. Okay. I appreciate it.
Eric for sure, because I would ask him because he did a protective order once before.
Oh, okay. All right. Very good. Well, thank you, then, Christian. I'll be working on this.
Because what part was on the what is actual confidential that needs to be protected. So.
Yeah. Okay, and so this has to be a mirror image. Okay, I got it. All right. Thank you.
Okay, next caller, you're unmuted. Arthur, you're unmuted.
Yes. Hi, Christian. How are you this evening?
All right, good.
Good.
Where are you calling from?
I'm calling from Michigan.
Michigan, okay.
And what I'd like to do, the reason why I'm calling in, I'd like to get under a trust ambassador here in Michigan.
All right.
If that's possible. I'd like to give you my Skype handle.
Yes, so why don't you do this? Don't Skype Faith to Trust.
Faith to Trust?
Yes. Are you in the NTT Welcome Group?
No, not yet.
Okay, so Skype Faith to Trust, and that's the 2 is number 2.
Okay.
And she'll connect you into the group.
Very
from
good.
From there, you can pick up the on a trust ambassador from there.
Okay, fantastic. That would be great. I really appreciate it. And that's really all I have for tonight. I'm still studying and listening to the calls, especially on the Wednesday night calls as well. So,
since you're new at this, let me ask you this. What do you find that is hard to understand?
What do I find that's hard to understand? I guess I'm so new at this, I don't know where to start.
Don't know where to start, okay.
You know,
are you aware of the ForShare site with the audios and that?
Yes. Matter of fact, I Skyped, I think it was Imagine the One, and also I got a hold of Carlos and another gentleman from, I don't know who he was, but from Wednesday night's call, he sent me a link to the ForShare, so I was able to get some of the audios there. And also I went back on the TalkShoe program and got some of the audios there.
So how many audios have you listened to so far?
I've gone all the way back to November and started out where you introduced NTT. Mm-hmm. So I've started listening from then all the way up to, I got as far as the end of June this year. So.
Oh, then you covered a lot of ground then.
Yeah. And again, I'm still studying, still going through. I'm currently in school full time, so when I'm done with my studies, I jump on this immediately and, listen to the calls and the audios.
Okay. Well, no specific questions or anything, or?
I really don't. Each program I listen to, I get my questions answered that I do have that come up through the week. So I'm grateful that you're on there and that you're teaching everybody.
Okay. All right. Well, I guess nothing. We'll go on to the next one then.
Okay.
Thanks for coming on.
Mm-hmm. Thanks, Christian.
California, you're on.
Hey, good evening. Thanks for taking my call. Can you hear me?
Yes. Who's this?
This is Jeff. How are you tonight?
All right.
Good. Hey, first one question was, for the protective order, would you maybe want to include the state secret from blacks in there? Is that considered?
I don't think include state secrets because state secrets of the state, and that's going to put you under statutory. I think.
Oh, so that'll pull you back into the statutory just by putting that in there?
Yeah, I think just about everything under that classification is going to be public except for the one that's confidential.
Okay. Answers that question.
One of the reasons why we got off of the CCI information, which was commercial confidential information. So that was really commercial, which is public, and we don't want to talk about that.
Right. We're not even interested in that. And you don't mention really substantive rights either, though.
I could in a colorable manner. Yeah, I could. Yeah.
Maybe just referring to nature's God's rights, things like that.
Yeah, you could put that in there. Yeah.
Okay. And also the indenture. When you have the indenture, you mail that in to the directly private to the judge and to the opposing parties.
At the time we're going to have a hearing, yes. Or maybe if needed in before to show that we got to have a hearing.
Well, yeah, say you filed a motion for a protective order. At that point, would it be good if they have the indenture as well so they know they have,
Well, what is the filing of the protective order? That's nothing more than an NOI again.
Exactly.
So you're making a claim that you need protection. Now what do you got to have?
SOIs.
SOIs, yes. Everything's got to be followed, an NOI with an SOI. If you don't have the two of them grouped together, you're not making a proper claim. That's supported and substantiated by anything. And then it'll time out. You won't get it.
Right. So the SOIs are material facts, and they could be in a pleading form, or they can just actually be material facts themselves. They could just be exhibits, either one. It could be in the form of an exhibit or a pleading. Okay. So, especially on the public side,
pleading would be
the NOI.
The NOI, yeah.
But there could be a SOI pleading basically as well to support that NOI.
If it was an affidavit form pleading, possibly, yeah.
Yeah, affidavit. Got it. That basically is supporting the facts or supporting the NOI. Okay. And I guess the other question I keep coming up with is the actual, are you still supporting the idea of creating a non-negotiable instrument out of the instrument where you actually write a check form? You know what I'm talking about?
Yes, I can either do a separate check form, special deposit looking check-like thing, or I could put that right on top of the debt title.
Yeah, right on. Make the instrument into it, essentially. Now, the grantor is entitled to write checks.
No, the grantor is entitled to make special deposits in formation of a trust or subsequently putting more special deposits into the trust.
So that's
he
just
can't
really
check.
Right. So it's a special deposit that you're writing then, because if you're really not going as the trustee, what what right do you have to write a check? You don't. You just have the right to do a special deposit.
Right. Right.
So if you're creating a check, then you're creating that check only solely as a special deposit, not really as a check, obviously.
Well, I'm never going to write a check. I'm going to write another special deposit as trustee as
Right.
payment and extinguishment of debt, say.
Yeah. Got it. But I think a lot of the people that are theoretically looking into using NTT are looking at being both grantor and beneficiary, and mostly we view the public officials as a trustee position.
Well, you can play it both ways. It just depends on how you want to play it, really. That scenario or grantor or trustee, one of the two.
Yeah, I guess the concept that seems the easiest to grasp at the moment is that they're the trustee because they have the access to the assets. Even though we are the assets, they seem to be having those kind of relationships where they could maybe access the assets easier.
I'm sticking to my former position when we first started all this, that you should be trustee outside of court, beneficiary inside court, as well as grantor.
Okay, so
outside of court, I want to be grantor, trustee. Inside of court, I want to be grantor, beneficiary.
now that's all one trust. You can actually take all those positions into one trust. I mean, wouldn't that collapse the trust? Or is
depends
that
on what side I want to play on at the time. Publicly, when I'm just making payments, I want to be grantor trustee today.
Yeah.
Now I got no problems. Now if I screw up, I got a problem, something hit me, now I can switch and I'm going to be a private beneficiary.
Got it.
Instead of the public trustee.
Yes.
And then I'll switch positions on the trustee or make them co-trustees or whatever.
Oh, co-trustee. There you go. So co-trustee, co-beneficiary, and grantor.
Yeah, I can play it either way. It just depends on which way I want to. Think I can do it better.
Okay. So publicly you could be the trustee, and privately you're the co-beneficiary and the grantor.
Yeah, publicly they want to see you to be trustee on the public side.
Of course. Okay. So I guess that's
by making the trustee payments, I run into problems, and if it got taken into court, then I could switch that if I wanted to. Then I'm going to be, say, beneficiary.
Got it. Okay. I think that's. Oh yeah. Also, the back to the green cards, the SOIs. Those. I don't know why it's so tricky, but those seem like they would be public, but they're private.
Here's what I think the confusion is. The green cards are not SOIs all the time.
Ah, yeah.
Depends on what side they're on.
I guess that's how do you exactly identify what side they're on? Like, if you're using the green cards for everything you mail in.
I think that's the whole root of the problem right there. It is being able to distinguish what is private and what is public, and that's probably what everybody's really having problems with.
Yeah. I mean, the 3811s are basically everything you send in has usually a 3811 attached to it.
Could be. Yeah, I could send 3811 green cards along with my presentment into the public side of the court, but why would I want to do that? Because I could just walk in there, file the documents with the clerk, get a certified copy, and I got a certified copy. Done deal. I really don't need a green card there.
That's true. That's true. That was my question. That was actually one of my questions was I would rather just have a conformed copy in my hand that's stamped if it's a public pleading. Why would I want to just send a green card in? You know, I'd rather actually have a stamped pleading.
For work I really don't need because I already got a certified copy from the clerk that proves that I've recorded it, so what more do I want?
Right, so that's sufficient. So really the only real green cards you need is when you're mailing something in privately and then they receive it, they sign the green card and the green card's your proof.
Yes.
Okay, that clears it up. That clears it up a lot for me. That makes the most sense. That way it's simplifying it. Any public pleading, forget the green cards, just go in, get a conformed copy, and any private mailing, use the green cards. Then you differentiate.
Yeah, it's not a conformed copy, it's a certified copy.
Certified copy. What's the difference?
The clerk is certifying that they got the original and they got it.
Right. So a conformed copy is just a copy that's stamped, though.
I don't know about conformed.
Okay.
Certified.
Yeah. In California, they call them conformed for some reason, but I guess that's kind of irrelevant. As long as it's stamped and it's the exact same thing that you turn into the court.
The copy you get back, they ask you, that's got a file stamp on it.
Yep.
They call it a conformed copy.
Yeah, I think so. Hold on, let me look. I think that seems like the case with all the things I've gotten. Usually they say filed on them, but then they do say conformed copy a lot of times. Yeah, conformed copy of original filed.
And you get a certified copy.
That's a good question. I'll find out. Yeah, for some reason, everyone, when you file them at the clerk window, they give you a copy back that says conformed copy of original filed. But I'm going to see if you can get certified. I'll do that next time.
Yeah, that might work either way. As long as I got a stamp on it, they're sealing and they're saying, yeah, they got it. And that's
right.
That's what
yes,
I want.
There's a signature on there from the clerk and a date.
Okay, that's sufficient, I'd say.
Yeah, that's proof. That's evidence.
Yep.
Okay, very good. And let's see, any other questions? I'm having fun learning it. It really feels a lot more comfortable than anything else I've studied. So thank you so much for that, for really waking us up. It's quite a process.
It's really simple when you get down to it.
It is.
Not that hard. I can't understand why it's got such a difficulty, but anyway.
Because of creditor-debtor. Anyone that studied creditor-debtor has really made it confounded and confused. A lot of this simple process. They made it a lot more confusing and complicated than it needs to be.
But it's based on a simple principle to support any claim. It takes two witnesses, and the two witnesses are records.
Yeah. Oh, speaking of that, I've really been having difficulty with county recorders. They're very, very, very specific about what they'll file. I've tried 3 different times and been rejected on public notices. I'm going to have to use the newspaper.
Well, I would tell them, if you don't file this, I'm going to sue you.
I was thinking about that. But
tell me you don't file notices and you don't file affidavits in there in the public records? Come on. I'm going to tell you guys to clean your clocks. I want to see your supervisor right now.
They're saying
get the legal advisor out here right now.
Court mandated is what they've been saying. If they're court mandated.
You show me the law.
Yeah.
The court's not the law.
Right.
Show me the legislature.
Yes, legislator. California people are very particular about lawsuits, it seems like.
Yeah, now are you making any kind of court pleading headings on any of these? Do they look like any kind of court forms?
I've tried it both ways. I've tried it with a pleading and I've tried it with just a affidavit style.
Well, yeah, don't put any court stuff on there.
Yeah, I went in first with the court when I found that out, but then I went in with just a regular affidavit, and they were just like, no, we can't file this, and this is a court-mandated document.
Oh, bullshit.
So, yeah, they were really giving me a hard time.
Get the supervisor out here right now. I want to talk to somebody who's in authority.
Yeah. So that's when it started giving me the idea of just, you know what, taking in the non-UCC filing form and just get them to do that, but you said don't do that. But basically what I was, because they will file
take it to another county if you got to.
Yeah, I think that's what I might have to do. That's sufficient as long as it's the same state, right?
Yeah, I mean, you can bring it in anywhere anywhere in the world I can bring it in.
Or the newspaper. The newspaper thing will work, though. I mean, that's just as well, isn't it? Or it's just not quite as official?
That's a little more screwing around, that's a little bit, yeah, you can do it that way, but.
I mean, they don't discriminate in the newspaper, though. They'll take anything as long as you're willing to pay.
Try another clerk, try another division or something, or go to a different county.
Yeah, I think I'll maybe go to a smaller county or something a little bit simpler. Los Angeles, they're really particular. I think they're really.
Really, I think if they're that bad at what they're doing, they're breaking the law. Because if they don't file notices and affidavits, they're breaking the law. There ain't no court in the world going to restrict you from not filing an affidavit and a notice in public.
Do you know what law that is? What reference I could, what code, what procedures that is?
No,
what
you
law?
have to dig around, but
Okay.
I can't believe that they would not allow you to file legally affidavits and notices. That's an assumption that is totally wrong.
Yeah, well, that seems to be a common premise in law these days.
Well, we need to get our balls together and go out there and clean our clocks and show them who's boss.
I agree. Okay. Well, I'll look into that, see if I can discover what law is supposed to mandate that we're allowed to get our public notices filed no matter what they say, and bring that up. If I got to have some evidence to present to them when they reject it next time. Okay. Well, thanks for your help.
Can you hear me?
Yeah.
Good, cool. I just added drafted by on the top of any of my recordings at the county, and they take them no problem. In fact, they cringe when I go in there now because they know me. So, but he could also look at nationalrepublicregistry.org because it's dirt cheap compared to what our filing costs are here. Per document here, it's like $56, and then if you want something certified, it's another $6 on top of that. But check out that nationalrepublicregistry.org website, and they were fast, and you send a self-addressed stamped envelope to get your documents back, and it's recorded not only on their website and World Wide Web, but they attest to it. They send back some cool affixes to it as well, and so that was really cheap too. So I just thought I'd add that for the last guy that was concerned. That's a Tim Turner website, but like I said, they were really fast, and it worked really good on the notices for like replacement of the county level type recordings. You know what I mean? Yeah. So I was impressed with them. Yeah.
What's the cost?
Oh, for 6 recordings, I think it was only $36 for all 6 of them.
Oh, that's not bad at all. Yeah.
Yeah, it was really cheap. Yeah. So, anyways, I thought I'd throw that out there.
Yeah, I think one other time we went over this, and they do have a public certification, so they can function as a public side.
Right. Correct. Yep. Like I said, they came back with blue ink signatures, the whole bit, seals on them, everything. Very cool. So that's a thought for county issues. You know, I don't have county issues. Like I said, I can walk in there and they cringe like, who's going to wait on her today? But I just don't want to pay their fees. It's ridiculous. So thought I'd pose that to him. Okay, that's all.
That's it?
That's all I had. Been just reading CJS and going on a road trip tomorrow for 2.5 hours, and I'll take my CJS with me again.
Okay.
All righty. Thanks, Christian. I'm out. Okay. Let's see. What do I got to do on this little keyboard now to sign off?
Show me, John.
Okay. Thanks.
Chris, you're unmuted.
Hi, Christian. It's Chris.
Hey. How's it going?
Well, it's going great. In fact, some of the research I've been doing on CJS is outstanding. I'll get to that in a minute. But what the lady was talking about is true, that there has been quite a furthering of success and acknowledgement by not just the counties, state, and federal government, but all of them are encouraging the registry to continue with the filings that we're doing and having it done through the private corporation that she was speaking of. And if you remember back when that first got started up under AIB.
Private corporation, but I think we went through this before. We found out that they do have a public certification, which makes them public. So.
Yeah, that's true. But with the exception that they also do private filings, of which you can hold in your safekeeping in case any issues do come up. So they actually accommodate.
So they actually store these private filings in some other different somehow because they got to be kept segregated from the public filings.
That's exactly true, and that's the beauty about it. And I would encourage everybody to go over there that can't get remedy. Now, to answer that gentleman's question and to assist you with answering that question, obstruction of justice is the charges that he wants to go after the county recorder's office. Anybody that is connected to refusing to file any document, especially under demand to file. When you say demand to file, regardless of what their prissy pantaloon panties would say or their background county attorneys are saying to them not to file, that's an obstruction of justice, that's a felony crime, and these people can be thrown in prison, not jail, but prison, for doing what they're doing to obstruct you to take care of your own affairs and your own manners, of which they're dictating that you have to follow their rules, and they're obstructing that means that that is with intent to prevent you from doing these filings, no matter what it is. If you get in trouble thereafter, that's a different subject matter. If you did something fraudulently or conveyed something fraudulently, those are issues that can come after the fact. But what they're doing is they're refusing across the board in all the counties in all the 50 states, and by doing that, that's obstruction of justice. And that is a prison sentence for these people.
Well, we need to enforce that, because if they don't file notices and affidavits, then that's, what good are they?
Well, okay, here's the other thing, and I know that you don't like to get into the debtor creditor stuff very much, and that's fine by me. I have no problem with that. But if some of the people go back over to lawlearners.net before it collapses and goes bye-bye, you can get some of those documents under county recorders that I put in there that gives you every combatant statute that goes after the county recorder's office and the clerk's office for failing to file documents that would otherwise protect your butt. So before I go ahead and give the consent to Darren, which is the webmaster, to close that thing down, I would venture to say for everybody to go over there and grab whatever you can, because he asked me, what do you want to do? And I says, well, because I'm dealing with so many cases, I don't know what to do, and I left it on the back burner. But when the dues come around for the website, there hasn't been enough volume of people to support it, so I'm going to go ahead and give the consent to close that down. And, it was a lot of work to put that thing together. As you probably know what it means to put something like that together. It's a lot of work. But those documents are over there, and people can get the obstruction for justice along with about 50, not 15, 50 other cases and supporting documents that says that anytime that they refuse to file anything, regardless of their own whatever, that they can be thrown in prison for it. And so that's the first thing. The second thing is, I was reading Corpus Juris Secundum, of which one of the gentlemen that came on the call tonight were asking about this secret profit. You won't believe this, but there's some stuff in here that would blow the lid right off of every case under bankruptcy or under foreclosure that these banks and these corporations can't get away with. And if you would allow me, I'll read a couple quotes out of it. Is that okay with you?
Yeah, sure, go ahead.
Okay. I'm not going to go through the whole thing. I did highlight everything I wanted to read, so you'll have to excuse me. I'm not going to go through the whole thing because it would be boring. This is under corporations. This is in CJS 5. And this goes into, section 100. Secret profits realized by such purchasers in the sale of a corporation when it appears that the defendants place themselves in a fiduciary relationship to the corporation by promoting it And while in that relation, by means of fraudulent representation and concealment, induces the corporation to purchase their lands whereby the secret profits were made. The way I'm reading that is you can easily construe that, of course, under debtor-creditor, that you are the straw man and you've been taken to the cleaners based off of people who have been in this industry for 300 or 400 years, taking advantage of innocent people. The next part here, that's right below it, that's A and B, is a promoter of a corporation or joint stock association may sell property thereto, but is incumbent upon him as a person occupying a fiduciary position to make full and fair disclosures of the interest and position with respect to the property, and not to make any false representations as to its cost price. And that goes into a California case of Burbank versus Dennis, 1894. That's 101C 9035, page 444, where a corporation was organized for the purchase by the promoter of the corporation's having contract of the purchase and deeds of various parcels, which were conveyed to the corporation, and for the promoter falsely reporting payment of a such larger sum than they had in fact paid. Here, right here is where I want to interject that when they take your promissory note and they fractionalize it, that's unfair practice. And so that was my thought on that particular part. In fact, that parsley payment was only were made upon the various tracts, I guess that's what it's trying to say, and that the deferred payments were secured by mortgage upon the land is immaterial, and the ease stand of though it were a cash transaction throughout. The promoter of a corporation formed for the express purpose of the purchase of a particular piece of property occupies a fiduciary relationship to the conscriber and are bound to truthfully declare their associate and personal interest they may have in the manner of the purchase. Without the disclosure, they cannot legally profit at the express of their associates. And what I infer about that part is that anytime that they take and prostitute the deed of trust and or the security instrument and they pass it to another person for their profits, that is not disclosed to the individual that had signed that document. Therefore, they're in breach. And not only that, but they have violated their fiduciary obligation to the original signer of that document. Well, let me continue. Let's see. Without such a disclosure, they cannot be legally profit, and at the expense of their associates, and one of the guilty promoters cannot absolve himself from the liabilities for such a loss by returning his shares of such secret profits. And that goes into Lamenta Land and Water Company versus Robinson under 1908. That's at 154C 36 at 97 P as in Peter 1018 LRANIS 1106. And of course, anybody that wants to go to page 778, they can read this for themselves. But some of the more important stuff, where a promoter's interest is an interest party in a plan to purchase property at a state price, conveys it to a corporation to be formed in which all shall hold shares. That includes people that have their promissory note out there invested as a shareholder. The plans being to sell the stock to the public through the promoter as trustee for the corporations, and the money required for the first payment is advanced by his associates, and that for the subsequent payments is expected to be received from the subscription of stockholders to become such in futures a secret profit obtained by the promoter by misrepresentation, the price at which the property can be acquired, and selling it to the corporation at a higher price than he paid for it, such secret profits being represented by the note of the corporations held by the promoter is fraudulent. And that's under California versus Calveras. That's M-I-N, company, I don't know what that means, versus Walls, that's W-A-L-L-S, 1915 at 170C, 285, 149P, and then that's 595. An option holder or a promoter will not be allowed to retain profits realized from the exercise of the options unless the facts of his interest and his options is disclosed in advance. That's Munson versus Fishburne, 1920. Option owners who are joint promoters are equally bound to make known to prospective subscribers the natures and the extent of their interest in enterprise, and that includes California case. And the last part I wanted to read to you that I thought was very pertinent with what we're talking about, I mean, it's right dead locked in. When persons associated themselves together for the purpose of promoting the organization of a corporation whose stock and securities are to be placed upon the market for sale to the public, any unreasonable profit which such persons derived from the organization of the corporations made possible only by concealment from those who have placed their trust in the promoters are deemed secret profits, which the corporations or the stockholders on its own behalf may sue to recover. And that becomes Beal, that's B-E-A-L versus Smith, 1920, and that is a California case 46 at CA 271-189, and I think that's P as in page, which would be 341. But I think it's really interesting, and I think it would really help a lot of people is to go through these CJSs and see related subject matters that goes into details of how everything is structured to have a better idea of how we're going about doing these trust mergings and whatnot. And I wanted to read that part because it really is pertinent to concealment, to lack of discoveries, and how these guys can be held liable under the CJS.
Okay, Chris, thanks.
Absolutely.
Yep. That's CJS, yeah. Full of information, and we never knew.
Yeah, and like I said, you know, I know a lot of people are they're wanting to understand what it means to be in the private, but I think that what needs to be really realized here is people need to understand what it is they're dealing on the public side so they can actually identify the difference between that and the private. That's kind of my point here. It's not so much to stay with the public and the statutes and whatnot, but to at least realize that these guys and the way the Constitution gave authority to our Congress and to our legislators is to have jurisdiction over treaties and commerce. Everything and all these laws are supposed to apply to them, not us. We are the private, and they misconstrued that. And if you just try to sit down and realize that they misconstrued what authority they had, and they've blemished the private, the people of this country, and brought them forward as a corporation. If you can just try to understand that what they did is they misconstrued and put us into the general sets of commerce that gives the Constitution gives the Congress and legislations the rules and regulations and codes and whatnot to have standing over all this stuff. But it was misconstrued. And the whole idea is that we are not of the general, we are not of the statutes, we're not of commerce, we're private. and this is where it might help some of the people on the call, is to realize is that we are special. We're not to be misconstrued as being part of the corporations. And this is where they had trespassed humanity by bringing us in and making us subject to the corporations and flip the coin on us.
Yeah. So let's give them a breach of trust and go straighten them up.
Yeah. Well, anyway, I just thought I'd throw that in. You know, I was excited to share this stuff. I'm not the best reader, by the way, so.
Neither am I.
You do a whole lot better than I do, I can tell you that.
I got a little more practice.
I'll let you get back to the next person.
Okay.
Thanks.
Well, I guess we got an empty board, so anybody press *6, *1 to get in the queue line, ask a question. *6, *1. *6, *1 to raise your hand, get in the queue line. Any questions out there? *6, *1, raise your hand. Anybody? Okay, nobody seems to want to ask any questions. Michael, you're unmuted.
Hello?
Yes.
I heard a question earlier, and someone said something along the lines of wanting, I'll use the word recourse, and that's one of the things I'm really trying to focus on as a backup for fraud and all those things. Do you have any links or ideas or codes or just anything like that? And I'll queue out.
Pertaining to recourse?
Yes, when they don't honor what we offer.
That's where enforcement would come in under the trust, I would say. That's what I would be talking about.
Enforcement. What links or what would that look like? I'm new. I'm fresh at this, and I really am. I particularly today had to deal with something that was first time, and I just want to say.
Well, actually, everything we've been talking about is kind of leading up to the enforcement. So, and the enforcement is what we're really on right now. That's about the position where we're at right now after 9 months. But everything leading up to that sets the foundation, sets the stage for the enforcement.
So that means we're speaking on it, or we will be speaking on it, or have I missed it?
Well, no. Really what we're talking about is how to get into court of equity to get our recourse, so our relief. And it's taken us 9 months to get here so far, so.
Right.
That's about where we're at right now.
Yeah, I'm hearing others speak from the standpoint of not necessarily a whole lot of others, just one other, which I don't think would be a problem if I mention his name, but it's just, if they're not going to do it, we need to, just take them to the court. I mean, take them, as one says, shut down the case.
Extinguish the debt, yeah. Merge the titles.
Okay, like I said, though, I'm just new at this now. I've come across some of everything what you're talking about and working with that. I just wanted to know where we are on the idea of remedy. I mean, not remedy, but so much of recourse, if I'm speaking the right words.
You might not be relief. If you're talking about remedy on remedy that law, and relief is inequity.
Okay. Well, relief. Put it this way, dealing with the fraud, dealing with they're not honoring paperwork, they're not honoring your words, they're not honoring anything that you have to say or that you presented.
Well, that's where they would be set up in a trust, and if they didn't do the performance what we wanted, then they would be in breach of trust, and we would go into a court of equity and enforce that breach of trust.
And the court of equity would be a perceived or a real place?
Well, it's a real place, but it's kind of tricky to get into, and that's what we're kind of discussing, you know, how to get into a court of equity, how to invoke a court of equity, and stay on the equitable side of the court rather than going and into their jurisdiction and be the defendant at the at-law side of the court.
Right, right. So we know what's right and what's available. It's just we're working on getting through that threshold, over that threshold of them honoring it. Is that what we're talking about?
Yeah, it's you got to go into the at-law side and get into the courts, but you just want to traverse in so far just to get in there without arguing the facts, so that you're not classified as the defendant and they have jurisdiction over you on the at-law side.
Exactly.
And we want to present a prima facie case in equity and have the court switch sides to where the private side of the public court is exposed, and we go into chambers, and that's where our real rights are as the real men and women, the substantive rights, where the public side of the court is just where we have form, process, and procedure, but on the private side of the court we have the substantive rights in chambers.
Right. So that's where we really do start beginning to see if we get in camera.
So that's where we're talking about how to invoke a court of equity, how to get into equity, how to maintain it so we stay in equity, and how to get a relief out of equity.
Right. Okay. All right. Well, I appreciate us working on it. And I say us because I tell you what, we do need each other mounting together and stepping one more step forward as often as we can. That's what I believe.
Yes. So recourse in Black's Law 8th edition, number 1 says it's an act of seeking help or advice. Number 2, enforcement of or a method for enforcing. And 3, a right of a holder of a negotiable instrument to demand payment from the drawer or endorser of the instrument if it's dishonored. And 4, the right to repayment of a loan from the borrower's personal assets and not just from the collateral that secured the loan. So 2, the enforcement of or the method of enforcing it. So recourse.
Mm-hmm. Would that include, I don't know, I'm just putting something out there. I'm so fresh at this. I'm just trying to see where my thoughts fit in, if they should fit in. Does that mean we should be working towards relationships with marshals or something like that? If for some reason we're not being, I don't know if served is a word, equity?
Well, from a court of equity, we're going to get mandatory injunctions issued at the end of the case that would order the parties to do the performance or the duty of the indenture or the trust. And that may be enforceable by the sheriff or possibly enforceable by the marshal, or else if they don't do it, they'll be in contempt and subject to arrest. So.
Yeah, I'm just wondering if that's what it takes, is we have to bring in special marshals or sheriffs or the like. You know, you go to somebody's court, they usually dominate and they usually rule there.
Yes, that's from everybody's brainwashing on the at-law side. The equitable side is totally different. It's opposite.
Right, right. Just getting there is my...
that's the hard part, yeah.
Yes, that's the hard part.
As hard as everybody thinks, I believe. That's a lot more easy than thinking about. Because they got this at-law brainwashing. They got this public side brainwashing. We've been slaves so long that we think, oh man, how are we going to get that? These judges are all against us and blah, blah, blah. No, I think if you get on the right side of the court and invoke a court of equity, that judge is going to be opposite.
Well,
difference between night and day.
Okay. I pray the best for us, and I'll keep on putting action to it.
Are you on Skype? Are you on Skype?
I don't understand Skype or know anything about it. I'm kind of illiterate about some of those other things. I'm just barely on Facebook.
So I was going to say, if you're on Skype, you can get into the NTT group and have access to all this stuff. And where you get the audio downloads for that? You have access to those?
I have access to a computer. I don't know anything about how to do all those other things. I'm not going to act literate on it because I'm not. But Skype is like
access to all the back shows starting in 11/7 of 2009 when we came out with NTT over the last 9 months with the material audio.
That's what's the difference is. This is only my second time listening, and for this long, first time listening. So I've been wondering, wondering how to get to those, and there's probably a whole lot more the same, not asking yet. So
well, that's why I was mentioning if you had Skype, because Skype would get you in connection on how to get to those places where they're stored on the computers up on the internet.
Oh, Skype is something I have to order? I don't know all that stuff.
No, it's a free program that you download on your computer, and it puts you into a chat mode with other people.
Chat.
And then you would Skype Faith to Trust, and she'll get you into the group and get you the schedules of the other shows, the times, and where the other audios are available, and get you in contact with some of the Trust ambassadors. And you know, it's really all done through Skype, really.
Okay. So am I understanding that the
do a Google search on your computer for my name, Christian Walters, in quotes, and then put after that or before that NTT, and you Google search that. Usually, about the first or second or so hit on there will be the ForShare site, which will take you to that where all the audio download links are since November of 11/7 of 2009 up till present.
Okay.
So then you can have access to the audios there.
Okay. Is that the archives?
Yes,
Okay, thank you.
ForShare site.
I'm sorry, I was coughing.
It's a ForShare site. Number 4.
Oh, okay.
Share.
ForShare. All right, thank you, Christian.
Either get there off of Google search or get through the Skype and somebody tells you what the link is.
Okay. Have a good night.
All right, thank you. Anonymous, you're unmuted. Anonymous, you're unmuted.
Oh, hi, CW. This is Rick in SoCal. How you doing, sir?
Good, Rick.
Good. Just a couple quick questions based on a couple things I think Floyd mentioned. Showing my ignorance here, but a protective order is written to protect what exactly? What are you doing when you do a protective order? Because I wrote down some of what you were saying about it, but you said you have to write a motion for a protective order, then you write the actual order. What is the reason for doing a protective order, and what does that?
They try to talk about your confidential information in the public. You have to object, and you have to show you have to manifest your intent, and you do that by the action that they're going to see is a protective order or an actual objection. I object.
Do you file that before you go into a camera, or do you file that afterwards?
Some questions as to whether we want to file it before or during or sometime, we're not exactly quite sure yet. If I come into court and they want to start talking about my private information, I could waive it. And I don't want to waive it. So I'm going to object in an open court and say that is confidential, it's private information, and we need a protective order, and I need to have a continuance of a hearing so I can come in with the information to show you that I need a protective order, because I can't bring that information into court because it'll be waived then.
So private confidential information in the court, if the judge tried to do that, would be something to the effect that you've filed a trust, you expressed trust, and he's trying to talk about your trust.
Yes, he would get you to talk about your trust, and you yourself would breach the trust because you're crossing public with private.
Okay. So if you in front of the judge and he says, "Tell me about your trust," you have to object and say, Your Honor, that's not something we can talk about in court. I'd be happy to chat with you in camera regarding that.
Yes, right.
And if he continues that approach, saying, well, I'm not granting any camera, you need to tell us right here, right now, that's when you would object.
Right, that's what I would say. We've got to set up a protective order so we can establish, rules of how we're going to disclose this information.
Okay.
And that actually sets up the need for a in-camera hearing.
Okay, good. And then the other gentleman, the light went on about the SOI and NOIs, and somehow, I don't know, it beeped or something. I missed a key thing there, but you were talking about how easy it is to understand. But I guess I did write down that in the public, you want to be seen as the grantor and trustee, and then you said in court you want to be seen as grantor and beneficiary. When you say court, do you mean in private court, or I want to be seen as a beneficiary?
I would suggest that in court you'd be seen on the private side of the court as grantor beneficiary.
Oh, so that's what I thought, private court, because public.
Now I could play it differently, but that's me.
Okay. Well, I'm not you. I'm not that smart yet, so I just want to get the basics. Yeah. Like grantor and beneficiary is what I want to be seen as in camera, and then when I'm in the public, which would be before the judge in the bar, if I was in the bar, then I'd want to be seen as grantor and trustee.
Yes.
Okay. And then just so I understand to the other distinctions you made, for the public, you said get a certified copy of what you're doing to record. All right. And then for the private, you just need to make sure you have your green cards for your SOIs.
Right.
Okay. So, all right. And the public, when you say the certified copy, that would be an SOI also, would it not? That would be a second witness?
A copy. Yeah, that would be the SOI, right.
Okay. Just wanted to clarify.
On the public side, the NOI would be my claim, my pleading, and the SOI to support that would be the notices.
Okay. And pleading. Okay.
Those would be the UCCs and the counties.
Reports.
And all that stuff I would file directly in with the clerk, and I get certified copies of that. And on the private side, my claim would be I've got a trust, that's the NOI, and then my SOIs to support that is all the material facts and the proof that they got it, which is the green cards.
Mm-hmm. Okay. Perfect. All right. That helps. Just want to shout out to Chris Summers. He's been on the line, and I know Randall Lee and I'd like to be able to talk to him. We missed an appointment over the weekend with miscommunication, but Chris, if you're still hanging on the phone call, maybe you could Skype Randall Lee. I'd appreciate it, and then we could set up a three-way call on that. So, but I appreciate you taking the time, CW, and hopefully everything's going to work out here for everybody. Thank you.
Okay. All right. Marshall, you're unmuted.
Hello.
Hey, Marshall.
Christian, how you doing tonight?
Okay. Did you get that phone straightened out yet?
Yes, I'm back on my Skype now.
All right.
No more cutoffs.
Great.
All right, I have one or two quick questions for you. Say, for instance, hypothetically speaking, if a person was to give a general deposit to, say, a bank for a mortgage for a house or something like that, and after time goes by, the person, say, gains sentient knowledge and decides that they want to apply certain principles in trust. Now, the principal company or the bank that you did this deal with is located out of state, which is different from your state of residence, per se. So now, when it comes to if you would have to be in some sort of a foreclosure proceeding, like, say, if you were to foreclose on them and bring suit against them, would that change a person's method of filing? Being that it's like an interstate type of a situation, would that require some sort of a federal action when it comes to, bringing a suit in equity?
It could, but then there's restrictions on the federal to connect the two jurisdictions or the two states, make them one. But you could sue them in state there, and if they didn't show up and defend the case, you'd win. You'd have a default judgment in that state.
Okay.
But the problem comes in is where you'd have to take it into, say, the foreign states and take that judgment in there under the Foreign Judgments Act and bring it in that state and enforce it, which I think would free to force it. I think you really do another trial de novo again. Within 60 days, if they don't respond, then you can get an automatic default from the clerk and get an enforcement directly from the clerk. Doesn't even have to be heard.
Okay, sounds good. Sounds good.
Now, under federal, there's certain restrictions, diversity issues, $75,000 limit. You know, it has to meet that criteria in order to claim it under a federal venue.
A federal venue, yeah. Okay.
Then you would sue them locally under federal, and they'd have to come in and defend, or else if they didn't, you'd get them that way.
All right.
Federal venue is a little stiffer on paperwork and things. They run a little more tighter operation, and everything's all done by paperwork.
Yeah.
Where the state courts is a little more flexible, and you get actual hearings and things and all that. So I don't know. I would suggest going in the state venue first, because that way you get your feet more wet with actual experience, and then you might be able to force it through the other state that way. And then if anything happened, I could still come in maybe later on with a second case and do a federal if I wanted to, in case I lost or I goofed up somehow.
That makes sense. Okay, so it really doesn't change anything per se, but it could in a specific sort of an instance. Okay.
Yeah, if you brought a state action and they didn't come in defending, you got a default, they'd be barred from coming in and taking your assets.
Right. Okay, cool. That cleared up something. That was good for me. Now, another question that I would have, kind of different from that now. Say that the Treasury and the DTC, how do they play into our, say, assets under trust? Like, I have a basic idea of what goes on. I know, say, the DTC holds all of our assets, but then I hear so does the Treasury. So when it comes to trust, how do we apply that to these entities in that manner, you know?
Well, the DTC is a depository trust company. It's just a company, not a corporation.
Okay.
That's just for a vehicle that they've created for the speeding up the trading for commerce on all these securities and things. So let's say the Treasury is holding the actual documents, but they've given the right of trading to the DTC, and then maybe the DTC is trading all these documents and things. That's how it ties in together.
Oh, all right. Okay. So the DTC is just like some sort of a subsidiary under the Treasury to help speed commerce.
Yeah, because it's in the indirect holding system where all securities are registered and held, so to speak, on one massive computer, and all they have to do is switch it from one account to another because they've got all the securities in their possession.
Right.
In one account, one entity.
Right. But the Treasury would
switch it back and forth out of one account to another.
So does that mean that the Treasury would still hold titles to it?
Yeah, they still hold the title.
That's right. That's right. Exactly. Okay. I think that's, yeah, those were the two questions that I had.
There's a difference between right of possession and possession. you could have the right of possession and not possess the thing or the res.
Exactly.
Somebody else possession. But yet the person who has possession of it does not have the right to the possession. They just have an agreement that they get to use it, so to speak, for whatever purpose. So they're one who has the right. And then there's the right to the property. So if you've got possession, right to possess, and right to property, you've got perfect title.
Right, exactly.
But then there's no perfect titles today because trust has split the titles.
Right. Legal title, equitable titles.
Right.
Cool. Sounds good to me. All right. I think that's it for right now, Christian. If I could think of anything else, I'll jump back in if nobody else is on. But I appreciate it. I just needed those 2 points cleared up for me.
Did you do any research on protective orders and that for like what Floyd was looking for? What the actual competent information would be?
Yeah, I actually sent Floyd a couple of things, as a matter of fact, as he was speaking about it. I Skyped him, and he has it.
All right.
I've been really working on my injunctions, and then after the call the other night, between the injunctions and like really focusing on my maxims and equity and like really knowing them like the back of my hand, and then the next thing that I'm really focusing my attention and concentration on is the whole guardian-ward relationship that starts from like the very beginning, like from the inception of you, the real live person, man or woman, like that guardian-ward relationship is formed like right then and there, and I need to know more about that also because it's very, very important and critical, and I'm sure everybody else would agree, but I just want to go back to the beginning, like something is just pointing me back to like the most basic of basics, and that's what I'm really trying to focus my attention on right now. Maxims, trust, of course, guardian and ward relationship.
How about the general versus special?
Well, that's been in the arsenal for a good good month or so now, 2 months since I don't know how long it's been, but since you first brought it out on the call, when you first started to teach us about it. I remember telling you before that the general versus special deposits call that you did was very big for me. I listened to it many a times, and I know that's also the basics. And now I'm not saying that I have everything down pack about general and special deposits, but I definitely know the difference between the two. Is some of the other elements that I really don't understand fully is what I'm really trying to focus on, and it just all points back to the basics for me. So it's just while I'm doing all of that, I have certain things going on myself and having to prepare for all of that, but then the basics will prepare you for whatever it is that we may go through. Everybody has their own situations that they're encountering right now, and we all need a remedy. Well, we all need relief, excuse me, but basics, that's what I'm doing right now. And you talk about the basics all the time, Christian, and I really follow that. I've always been like that anyway, so basics.
How are you coming on the injunction part? You temporary restraining order, preliminary injunction, permanent injunction?
Yeah, well, what I'm figuring now is if I'm going to bring, well, if one was to bring, say, a action against a corporation, a bank, or somebody, they would start off with a preliminary injunction. So, but if it was to be started against the person, then it would, transform to a temporary restraining order. So I'm kind of going through both right now because it's something that I want to learn about and know about, and I went to the law library and I copied about 200 pages from CJS on injunctions, and I'm going through it with my highlighter, and I'm just absorbing as much as I can, and I'm really learning a lot about the injunctions and the elements that go inside of it and what the courts are looking for and the prerequisites and the certain elements that are mandated. And I also see that irreparable harm and irreparable injury is something that's very, very critical as far as any type of equitable injunction is concerned. And it's like it actually tells you this, and just putting together the material facts. Like, that's the one thing that I want to also get a grasp and a full hold of. Like, I know our SOIs are our material facts, and I have a good understanding of it, but when it comes to putting things on paper is where I like to be precise and sharp with it. So that's another thing that I'm taking on a lot right now, and we all are, but I actually enjoy it. You understand what I'm saying?
Right.
So those are the things that I'm working on right now, me personally, and it's a lot to do, but like I said, I got help, got advice from, people such as yourself, the other trust ambassadors, and even speaking with people on the NTT chat, some of the certain quote-unquote newbies, like some of them I give credit to because they've been really, really trying, and they've been reaching out to the trust ambassadors, and they spend the time to, well, not all of them do, but the ones who do are being recognized, and I would like to, give a special shout out to them if any of them are listening. You know who you are, and keep up the good work. I just wanted to put that out there for you guys, and we're here. We're not going anywhere. So once again, appreciate it, Christian. Thank you. I think I'm going to sign out now.
I've got any difficulties with the SOIs in relation to the elements on the temporary restraining order or preliminary injunctions?
Say that again?
You got any questions on the elements or the SOIs that get tied in with the preliminary injunction? You said you had some questions maybe on that?
Well, as a matter of fact, yeah. As far as the material facts, okay, so in a preliminary injunction, it would be you foreseeing some type of you would be, I guess, preserving the status quo of the situation. Am I correct?
Yeah, that could be one of the reasons for it, yes.
Okay, so if you're preserving the status quo, when you say that is a reason, could that would not be a fact, was it? Could it, I should say?
Okay, those would be grounds or reasons.
Grounds, okay.
Grounds for why that should be granted. But here's the thing. Maybe you don't have direct evidence to prove that something is happening.
Okay.
But if it happens, it'll be too late. And now, since it's going to happen, and I'm going to be irreparably harmed or damaged, that gives me a reason why this should be stopped so that I can have discovery, and through discovery I can come up with the grounds.
Ah, okay.
So all I would have to do would be to come up with a prima facie attachment, which would be an affidavit, and that affidavit would be sworn testimony that there are grounds out there that need to be uncovered, but yet I can't uncover them yet. But if we have this preliminary injunction, I intend to show that such and such exists.
Okay. All right. Okay, so let me think.
Even though that the actual grounds may not exist, but we're leading to, we need some kind of stoppage and a stay, an injunction here, so that discovery can be done, and discovery will lead to the material facts to support my counterclaim or my accusations.
Okay.
So prima facie, at least on its facts, would be a affidavit with proper foundation to set up information based on belief, information and belief, that such and such is going to happen, and when it does, I'm going to lose a right, and I'm going to be irreparably harmed and damaged. So even though you may not have or see the grounds for the support of the element, you can at least make a sworn statement to support it. And that's prima facie, and that's good enough in some cases. Now, naturally, if I've got some hard direct evidence, I would support it with the direct evidence, copies.
Right. Because that would be, you know, a thought of mine. I would say, if you know that there's been some type of a harm done to you, you should be able to put it down on a piece of paper in layman's terms. But I know, you know, practice.
Yeah, and then substantiate that with some kind of sworn testimony from someone else, documentation in some way, and then that's where the rules of evidence come in, where you can look through the rules of evidence and find out what is evidence and what is hearsay and what is, you know, the exceptions to the hearsay.
I actually have all of that. The very first time I went to the law library a couple of months back, I haven't been there in a couple of years since, but when I started going back dealing with NTT, that was the very first thing that I went to the law library to get, was my rules of evidence, inadmissibility and opposed to admissibility of evidence, and specifically for North Carolina. So, yeah, I could definitely understand that.
So I thought maybe that might help.
No, it definitely did. Well, it just cleared up some things for me. That's the greatest thing about it. I was able to get some things cleared up. Okay, so
don't ask, otherwise I'll pull it out of you.
Well, what it is like, if I was to sit down and prepare, you know, I jumped on the call and certain questions I have in my mind, but I like to, you know, formulate the questions that I want to ask you, you know, prior to me actually getting on a call with you, because I want to be very specific and precise, because you're going to give me a very roundabout but direct answer just when it comes to hypothetical situations that I may be thinking about in my mind or so. But I like to be prepared. Last couple of calls, I've just been kind of shooting from the hip with, you know, certain questions that pop up in my head, but next time I'll be more prepared. But once again, thank you very much.
Okay, Marshall. Appreciate it.
All right.
Thank you.
Have a good night.
Eric, you're unmuted.
Hey, Christian.
Hey.
This is Eric.
I know. How you doing?
Hey, great. Hey, there's been a little discussion floating about, and I did a little bit of research, and I put a couple ideas together, and I want to discuss it with you, and maybe we can even open it up to some of the other TAs and get this thing ironed out. And it has to do with being able to provide what it takes for a determination of trust to be accomplished, which is obviously in page 1 of Gilbert's. And then what I did is I was looking at Maxim 120, equity will not suffer a wrong to be without a remedy, and there was a key sentence in there that I think that these two things are associated, and I don't know how significant they are, but maybe we'll catch a bingo here. That's what I'm kind of hoping for.
Oh, you bring them in at 2 hour and 30-minute mark?
Well, we could save it for tomorrow if you're getting tired.
Where you been all call?
Well, if you want to save it for tomorrow, that's fine.
So what was the one you mentioned? The remedy what?
The maxim, you mean?
Yeah, equity will not suffer wrong without a remedy.
Yeah, right. And the sentence that jumped out in that maxim is even where the suitor is clearly without a relief at law, he will not be aided by chancery unless he belongs to the class recognized by it as entitled to relief. So when I think about the class recognized, how do we get into that class? To be recognized. So then I thought to myself, is it simply...
Did you check your Skype?
When?
Well, let's see.
Not today, you mean?
Yeah, we're kind of running this through at the time you talked to me about it.
Right.
Did you find any case supports for that?
I didn't look on that site that you sent me, and so I guess what we really got to do is we got to get more explanation within the case that they're talking about within the maxim, huh?
Yeah, because I let me see if I got it. Right, here it is. Look. That was 120?
Yeah.
Okay, so continue on where you were talking. You were talking about the class.
So what I'm wondering is the class recognized, is that class created from being able to provide the evidence so a judge could make a determination of trust talked about in the first five pages of Gilbert's.
Okay, could you quote that again, what you were reading out of 120?
Out of 120? It's on page 339 in CJS, and it's in the first paragraph on the left, and it says, even where a suitor is clearly without a relief at law, he will not be aided by chancery unless he belongs to the class recognized by it as entitled to relief.
Okay, you got to maybe back up at least another sentence or back up into the context of the...
Okay. Let me get the page 338, and then I'll back up into the context a little bit.
Go where the paragraph starts.
Say it again?
Start where the paragraph starts.
Yeah, that's what I'm going to do. In accordance with the maxim, where a statute creates a new right which cannot be adequately enforced at law, equity will contrive remedies and orders to enforce it, unless the statutory remedy is exclusive. However, the maxim is necessarily subordinate to positive principles and cannot be applied either to subvert established rule of law or to give the courts a jurisdiction. Hitherto unknown, and it is only in a general and not in a literal sense the maxim has force. There are numerous classes of cases where equity will afford no relief, although the party has no other adequate remedy. Even where the suitor is clearly without relief at law, he will not be aided by chancery unless he belongs to the class recognized by it as entitled to relief.
All right, so they're talking about in there, it says there are numerous classes of cases where equity will afford no relief. So that's what they're basing it off of right there. There is sometimes, some circumstances, some cases where nobody's going to get a relief. It's just not possible. The law can't give them a relief. And they gave cases under 51 where it said there, U.S. Thompson versus Allen County, Kentucky, and that one, I pulled that one up and gave it to you. Remember, did you read that one?
Let me go back and look at our
and then
chat.
Oklahoma, Wagoner County Election Board versus Plunkett. I didn't find that one.
I'm going to have to go back and do a little review of the history to see if I got that.
So down in the footnote, starts off between 51 and 52, it's separated with equity does not right every wrong, because it can't. There are some things wrong with the legal system that it just, certain circumstances, it can't give you a remedy. And then it lists Tennessee under Turner versus Harris. Now, I found that one. Now the next sentence out of the text, it says, even where the suitor is clearly without relief at law, he will not be aided by chancery unless he belongs to the class recognized by it as entitled to relief. And that's 52 footnote. Then that was California, Tutt versus Van Voss, and I don't know if I found that one or not. I don't think I could. But I found some similar cases with that, and I wasn't sure whether or not they were under the same context, but anyway. Then there was Wisconsin. It was Pichette versus Milbrath, where the rehearing was denied. I believe I found references to that also, but I gave you the sites to kind of check with it. But there were some interesting facts that were uncovered with those, and that's why I asked you if you checked your Skype.
Well, the only thing I got was a one link from you, if it was directly from you, where
yeah, it was a big link
where I could research, I guess, some different things. I'm gonna have to review that when we're not online here. But the reason that I brought this point up is that what we might be able to, this might give us an opportunity as a foundation to understand equity as a whole in a better way for everybody. So that's why I suggested this area of study, because I think a lot of people would benefit from just understanding equity better as a whole, as far as what type of classes of cases equity would afford relief to, and what type of things equity would not be in the realm of equity, just so we understand the duality and what is equity and what isn't in terms of cases.
Well, not so much the duality. I would say just so that you could run your life in a more ordered fashion, in a more righteous manner. Because you're using equity, or let's put it this way, you're not using equity in your life, and you should be, on every one of your daily decisions. And if you don't, you're probably not using godly concepts. Now, I don't want to say that all of equity out of corpus juris secundum is on par with, say, the scriptures, but I do see a correlation between the two, and maybe taking the scriptures in such a way as to incorporate, or to how to incorporate them in your life, because it is equity. Just like Romans 12:2 says, you know, hey, we've got to become aware of the pattern of the world thinking, and what is it? Because we have to have the knowledge to discern what the will of God is, according to these matters. And you've been brainwashed with the barn thinking all your life, and you don't know it stinks in here. And when somebody tells you it smells, you tell them, what are you talking about? I don't smell a thing. You've been in a barn too long, and you need to switch your attitude thinking. You need to have a paradigm shift of your thinking from the pattern of the world that you've been born with.
So what I'm doing when I'm reading the maxims is I'm looking for things like this that can provoke this kind of conversation. And this Maxim 120 has a few of those, and if you'll allow, I'll read on a little bit that'll really get a lot of people thinking. And it says, the maxim applies only to those who have not had their day in court, and it does not afford a second remedy to one who has lost the remedy provided by law through failing to invoke it in time, even though such failure accrued without fault or negligence on his part. So failing to invoke it in time, that goes right back to the beginning of us creating our records and stating our intent and doing it 3 times on the record in court, so the judge will clearly know that we know who we are and we're sure about what our intent is. Am I on point with that?
I would say so, yeah.
And one thing that I want to make sure that everybody gets out of our conversation is that I've had some conversation with somebody who had a recent event in court, and this person failed to state the 5 statements 3 times, and the judge said, well, that's fine, but we're going to trial anyway. And what my thoughts on this were, was the judge was testing this person to make sure that they were dead sure about their intent, and when they only said it once and then didn't say it again when the judge says, that's fine, but we're going to trial anyways. Is it simply that the judge was testing this person's intent and was looking to see if they're willing to state it on the record 3 times? So my question is what is your deduction on that?
Yeah, I always push it to the 3-strike rule because on the 4th then you definitely got a dishonor. First time's fault, second time's default, third time's dishonor.
So that needs to be a rule consistently for anybody going to a public hearing. They need to make sure that they get them into dishonor by putting it on the record 3 times.
Yeah, I think that really shows your intent because you were swayed that you didn't say anything. And you had the right. You waived your right. But you swayed your intent.
And they're going to try to do that. And that's what they got to do. They got to find out if you really know what you're talking about, don't they? That's their job, isn't it?
Yes. Yes, they're the watchers on the gatekeepers. They got to test you. But we think that they have to do it our way. And we think our way is their rules. It's not. We are so self-righteous, so self-centered, so pig-headed that we think everything pertains to us. Get a life. When you go to France, you aren't going to tell the French people how to run their government. When you go into these public French courts, you're not going to tell them how to run their courts. You got to know the rules of the game. And they even ask you, do you know what's going on here? Well, you need an attorney. Be wise as a snake and gentle as a dove. Art of Sun Tzu. Know yourself and know your enemy. You want to get a remedy, come in humble. You want to get a relief, you better come in humble.
So, going back to the maximum 120 and the lesson that I read about the maximum only applies to those who have not had their day in court. So let's maybe talk about a scenario that somebody might find themselves in where they haven't had their day in court and how it would apply. Because it says equity will not suffer a wrong to be without a remedy. Do you have maybe a scenario that might apply to folks that they could identify that with where they haven't had their day in court?
Well, when you're seeking an equitable relief and you've been wronged, the person that's been wronged, you've got the stronger hand. And the stronger hand is the one who has the right or the capacity to ask for the legal remedy, that equitable relief. And in equity, this form of remedy is usually the one of specific performance or an injunction, the mandatory injunction, say. And these are the superior remedies to those administered in common laws under the damages.
So would this be, for example, something that we would invoke prior to going to court, so we could control the public from the private? Is that appropriate?
Or something we want to invoke prior to going to court? Well, I would say, yeah, you'd have to invoke it either prior and also during court.
Because it says only to those who have not had their day in court.
Yeah. Well, did you look up the examples for that equitable maxim? Did you look up the Ashby versus White and the Bivens versus the 6 unknown name agents?
No, I'm obviously going to have to, but so we're just going to have to look at the cases and see how all that came out in the cases that they derived it from.
Yeah, I'm thinking, your examples you want to be looking at are actually the case sites that are going to support those equitable maxims.
Now I'm going to switch gears, and last night I was watching Meet the Press, and Alan Greenspan was on there talking.
Mm-hmm.
And I suggest everybody watch and listen to that man, because he talks about mergers and schisms, and he's a very brilliant, intelligent man, and I think that just listening to him talk, we could all learn quite a bit about what it is we're trying to accomplish.
What was the topic last night?
What things look like in the future in the housing market, and interest rates, and policy. There's a bill being passed by Congress for the Federal Reserve and somebody else to have more policy making power.
For what, more control?
Yeah, like they don't have enough. But just to listen to him speak, it was and of course he's retired, but to listen to him speak, I have to suggest if that guy comes on TV or is on the radio, listen to what he's saying, and you'll hear things in a way that you never did now that you're involved with NTT. Because I sure did. There were light bulbs going off all over the place when that guy was talking. When you think about where your substance really is, and how it's all created, and how they bring it through to the public, and all the things we talk about all the time.
So what else in regards to the equitable maximum? Anything else?
Let me look here. Well, and then it goes on after it says failing to invoke it in time, even though such failure accrued without fault or negligence on his part. But if we failed to invoke it and state our intention 3 times and get that judge into a dishonor, that would be by our own fault or negligence. Correct?
Yeah.
So what I'm trying to figure out is that it says the maximum only applies to those who have not had their day in court, and it does not afford a second remedy to one who has lost the remedy provided by law through failing to invoke it in time, even though such failure has accrued without fault or negligence on his part. So that creates an interesting question. So if we were to invoke it and get the judge into a dishonor, then I guess what this is saying is the maxim still applies.
Yeah, because you didn't have your day in court.
Okay.
Didn't get it.
And then the other thing that I was comparing this with was the determination of trust, because of the conversation I had with somebody who went to court recently, and the judge said, well, that's fine, but we're going to trial anyways. And I don't know who was chatting about it, but we were talking about determination of trust. It might have been you, Christian, and I think it was now. And said, go back to page 1 of Gilbert's. So, of course, that got me to go back to page 1 of Gilbert's to just look at the basics once again. And if we don't understand the basics of what it takes so the judge can make a determination that a trust exists, then we've just stopped at the gate. We've never even gotten out of it, much less around the track. And going back to what we started talking about months and months ago, you have to be able to get the proper records to the proper people, both in the public and the private, in order for that determination to be made. And if it's as simple as that. There's nothing more to it, right?
I don't think there is, because really, if the starting gun went off and you're running the race, I think what you've done is you traversed too far to the case. I think you win on the starting line. Like all of them line up in a row there, they get down to position, and okay, before the gun goes off, this one, that one, and that one, you get over on there. The rest of them got to run the race.
And those 3 are already considered winners before the race even takes off.
Right, you're on the other side over here. Yep.
Okay. So it's as simple as doing our records properly, making sure they're sent properly, and the right people get their hands on that, whether it be the clerk, our trustee, and then the person who's going to help us enforce, for example, the judge, for example.
Yeah, now we might have to educate these judges a little bit on what they might be doing, because they might not all be up to speed under the same thing. Now,
But I wouldn't take no for an answer. You know, if I got some judge that, you know, he hammers somebody, I wouldn't give up there. Because maybe he was a rogue judge or maybe he was totally wrong.
And if that judge was a rogue judge or totally wrong, what type of thing would a person do if that were to happen to them? If they were to have that experience, would they go, for example, to the chief judge of that district, for example?
No, I'd go under an appeal.
Okay.
Appeal or higher court. Look, if I knew that the maximum was right and I was supposed to get a remedy, but that the judge went against me, am I going to give up when I know I'm right?
No, I know you're not. Some folks might, but I hope everybody shares your conviction.
Yeah, we only lose when we give up. And that squeaky wheel gets oiled first. So I'm going to do a lot of squeaking.
And then, of course, we have some options with compelling the judge to not breach.
Yeah. We haven't even gone there yet.
So when everybody's thinking about how they're going to present their case, and if they do run into a rogue judge or one that they failed to educate properly, maybe they might want to start thinking about how to compel that judge not to breach. And
I really think I think most of these judges would like to help you out. If you could just give them something to help you out with.
And that might just be simply some supporting authorities, some case law that they need to see, that they can go, oh, you are right, thank you. Some maxims. What other kind of things do you think they might need?
Well, I think the maxims runs the equity side, but they may be so not used to seeing maxims that what the heck is this? You know, they might not know. So I'm not going to put any at-law side stuff in the pleading. Just the maxims, claim the maxims. If the guy hammers me for whatever reason, I'm going to take it up on an appeal. Now, I know for a fact that the appellate courts know more than this funky judge down below does.
The county judge, for example?
Yes. You don't get promoted upstairs unless you know something.
And just to give everybody a kind of a basic understanding of, for example, the court system here in Florida, we have the county courts, and then if you were to take it to an appellate court, would that be a state court, for example?
Yeah, appeals is in state court, yeah. You're going to go up, yeah.
And then that would be the appellate system, and then if you were to if a person was not to be successful there, then they would go to the Supreme Court at that point, in that order? Or is there another level?
I could jump into federal, maybe. Come up with some new facts and come in there.
But here in Florida, for example, or most states, what we're going to have is the county, then the appellate state court system, and then the next order up is the Supreme Court within that state, right?
Yeah, I'm not so sure if I'd go into the county. That's like, if somebody didn't know what they were doing, maybe to go in the county and find and get their feet wet so you could get into the state. But, you know, I don't know if I'd come into county myself.
You mean if you were filing an action?
Yeah, I think I'd come into the state myself.
That's if you were making a claim, but what about if you had a claim made against you in the county, then you would have no choice but to answer within the county, right?
I'd still change venues and pull it up in the state.
So when we do our counterclaim, it's altogether possible to do that.
Yeah, equity is going to prevent a multiplicity of suits.
Well, then obviously folks listening to this might be thinking about how to find out about their state court system, because that's probably the better place for us to be stepping into.
No, I didn't say that.
Okay.
I said based on your knowledge and your experience.
Okay.
If you don't have any knowledge, you don't have the experience, I'd start out in county court. get beat up there first. Get some experience under you. If you knew what you were doing, had some experience in court, knew how the court operates basically, then I'd say maybe come into state court or federal court. But there's so much people have to learn. Not only just, they got to learn NTT, they got to learn how to operate in court. And most of this stuff is people just don't want to do it. But I'm sorry, that's just the way it is. You either do it or you are a slave. Me, I don't prefer to be a slave, so I'm gonna do it. Till we get some other better remedy that we don't have to go to court. Right, that's the way it is. And going to court is not the same as what we think, because everybody's getting beat up on the at-law side. We're not operating on the at-law side. We're operating on the other side, where they are operating at and beating you up at. And what gets you in court is the equitable side of the court in your breaches of your so-called debtor contracts for a lack of performance. You didn't pay. You think that's admiralty? There's no way. That's equity beating you up. That's a trust. And here you've been getting beat up by a trust all along, every day, and didn't know it. Now, why don't you get smart, go in under a trust, and you be the 900-pound gorilla, and they be the trustee defendant.
And make your prima facie case. Like that, Yeah, because they don't have to prove the facts. It's just they make a prima facie case, and now you got to defend yourself. Well, that's not admiralty. That's equity. Burden of proof shifted against you. You're the trustee. You're the defendant, and you're presumed to be guilty. And the only thing court wants to know is when you're going to make a payment. Doesn't that sound like how you got foreclosed on? Doesn't that sound like how you get beat up in court? That's been going on since the 1500s. Boy, are we dumb. Well, folks do enjoy their Jeopardy and their Price is Right, so keeps them from...
We've been living on borrowed time in this country, thinking that we are living in a utopia. Well, I got news for you. It's catching up with us. There are now very few responsible people out there doing government. People don't know how to do government. They don't even know what government is. Blame the other guy. Blame them. Oh, blame the people you send up there, and then turn around and elect the same stupid people again, send them up there again. Who's the fools here?
Basic government is making a claim and having the evidence to support it, right?
Yeah. Well, let's get back on NTT. Get off the soapbox here.
Well, I just want to discuss the maxim and if determination of trust could be one of the classes that equity would recognize, or it could get you into a class. And I'm just trying to figure out whether or not my thinking is really appropriate there. But we got to look up the cases to really determine that, it sounds like.
And then take it with a grain of sand or salt, because what you're reading is statutory too.
Of course, yeah. Well,
I think the class that they're pertaining to in that context is those that didn't get a remedy, those that can't get a remedy, and now what are we going to do for them?
Well, I'll suggest to everybody that listens to this, go and read the maxims. If you don't have them, please ask for them, and try and come up with questions like I did, because the more you read them, the more you're going to learn. And go back to the first 5 pages of Gilbert's and see what you can learn from those two things, because I've been at this a while and I still keep on learning. Thanks so much, Christian.
Those maxims, if we could start seeing them as models and then start plugging things in with variables, then they become actual tools to use in application. They're kind of like Tinker Toys, or erector sets. They're the links that you put together to build something with. But if you don't have the links, you don't have nothing. You can't build anything. And that makes a difference between success and failure. Because only those who spent the time at it are going to know it inside and out, like the back of their hand. So when the judge says, I don't see a trust here, what do you tell him? Or when the judge says, your private trust has no legal, lawful, or any form of standing. Are you going to stand there dumbfounded and in shock? Or are you going to have an instantaneous answer for him? Otherwise, you're going to get dismissed for failure to state a claim upon which relief can be granted.
Well,
he just told you that you didn't prove your trust. I don't see a trust here. In so many fancy words.
But we can't prove it in the court. We got to go in a chamber so I can show the evidence.
Yeah, but he has to see something prima facie that is the smoke and mirrors thing that they give you, that you got to show him that's colorable, that they can say, okay, I see something there, but we got to go into the chambers to get this cleared up.
Well, that's going to be a notice in affidavit form.
Yes, that's how simple it is.
You have to state on the record that there is a trust, so he can see that you stated it on the record.
I believe that what that person didn't do was attach a document to their pleading that gave them standing, which was the form, and that form was an affidavit. The form that they could see on their colorable side that would have made a prima facie case and set up enough there that they would have had to go on with the trial and do the in-camera and set it up as for that under trust. Basics. Back to the basics again.
I hope I could always return us back there so we can get more and more success.
Okay.
Because that's where it seems like everybody's getting stuck. And if you would ask everybody that when they're communicating on the chats, if they'll ask their questions in hypothetical forms, us TAs would really appreciate it.
Yeah, well, yeah, that's what we're going to have to do. Yeah, we need to put our questions in hypothetical forms, no more talking about specific cases from this point on, or else I'm not going to answer any questions about them.
And we all want to help, so please let us have that opportunity, everyone.
Okay, is that it?
Yeah, thanks so much, Christian, and great call tonight. I'll try and come up with more questions out of those maxims so we can all glean more and more.
All right. Okay, everybody, it's after 3 o'clock. Bad enough for tonight for me, so I'll see you tomorrow night at 10 o'clock.